Please, I'd like to mention for listing one repetition, Lordship, this is regarding non-payment of family pension, Lordship. Can it be on 9th of December?
Let it be in January. January. 19th January.
Lordships, item 13, if I may seek your indulgence to mention, this is the same problem matter which was coming up at the end of the list,
Item
13.
1-3.
Yeah,
We'll see how we can accommodate you.
it's, if you can just push it up. I may be sounding greedy, but then if it can be pushed up a little,
No, we'll see.
grateful.
Yeah.
May I please sit? I beg to mention for listing, my lord, admission matter, my lord, 2013 matter. On my lord, second week,
2005 matter,
13.
13 matter for admission.
Yes, sir.
Or 7th January. 7th January.
My lord, I beg to mention one motion matter, my lord. I am filing today itself, my lord. Already it is filed, my lord.
Why do you want to mention
My
it?
lord,
for
tomorrow,
filing?
my lord, for tomorrow, because my lord, a
Why?
constable,
You file it first, and then you make a mention tomorrow. We'll see.
no, lord, yes.
You
tomorrow.
file it.
Constable, my lord, selection.
You file it tomorrow. You file it before you are filing. You are making a mention.
No, already filed, my lord.
What is the number? Filing number.
Filing number has not given.
Then you file it and make a mention tomorrow.
I will
May I
explain.
please, your lordship, prayer for listing, 2023 matter,
Uh,
matter regarding for compassionate appointment,
19th January.
19th.
Best.
May it please your lordship, my lord, item number 5, petitioner died, my lord, I do not want to press, may be closed.
Who are you to press or not press? He's already dead. What about his legal heirs?
My lord, I talked to them, my lord, their wife said that, my lord, she does not want to press, that's why I am submitting. Dismissal matter,
Why it is submitted by the counsel for the petitioner that the petitioner expired. When?
my lord, 2-3 months ago, my lord, she informed me tomorrow.
The pendency of the writ petition, and the counsel for the petitioner claims to have been informed by the spouse of the petitioner. And it is submitted that the legal heirs of the petitioner are not desirous of pursuing the litigation any further. That view of the matter, the petition stands, is abated, stands closed. Interim orders, if any, stands vacated. Pending ayes are also dismissed. Liberty, however, is granted to the legal heirs to file appropriate applications. It goes so to file. Yes.
May I praise your lordship? Lordship, I beg to mention for listing of a writ petition bearing number 7806 of 2022. Lordship, the matter was last listed on 30/10, Lordship. The Standing Council for Finance Department has taken time, Your Lordship. Readings are completed, Lordship. Kindly, the matter may be listed for admission, Your Lordship.
Admission on 7th January.
Yeah, Lordship.
Yes.
Yes, please, your lordship, my prayer is for listing WPC lordship regarding compassionate appointment lordship. Lordship, our
January, take a date in January, 9th January.
lordship before vacation any date lordship. Because DLC held in very soon lordship.
No, 9th January, the earliest we can give you. Yes.
May please your lordship. Lordship, I beg to mention for item number 3 of the today's course. Lordship's leading counsel is out of station, so another date may be fixed, lordship.
This appears to have become infractuous. This is 2016 matter.
Yes, lordship.
We can't give you time like this.
Lordship, I have only been instructed in the morning that
No, can't be helped. You wait. There are so many councils, none of them are available.
lordship,
You inform the councils that we are proceeding against all these councils
lordship.
and sending the matter to Bar Council for taking necessary action against all these lawyers whose names appear.
Lordship.
You are not in the matter.
I'm not at all.
No,
in the-
so we are taking, you inform the council who has informed you. So many lawyers are there, none of them have appeared in a matter of 2016.
Lordship, I can inform, but I have been only instructed to.
So you inform them, you tell them this is what the court said. We are not adjourning it.
Lordship.
Yes.
Yeah, please lordship. Lordship, with the consent of the other side lordship, I beg to mention item number 7 lordship.
Yes.
Right.
I am for the petitioner, my lord. This is the pension matter. I'm praying for only date, my lord. Date may be fixed because we.
You allow her to complete the mention first.
My lord,
Your objections will come only when you
my lord.
want to hear you. Yes,
Lordship, kindly adjourn the matter for the day lordship.
for the day.
Yes, lord.
All right. And what is your objection?
My lord, this is the pension matter, my lord.
Mm,
The petition is without pension from 2023, my lord. So my prayer is only date may be fixed, my lord.
Date fixed, it is already not a fixed date, all right. Matter be listed on 8th of January. 8th
My lord.
January.
DPH.
May I please, your lordship? Lordship, I beg to mention for listing of WPC for admission, lordship.
9th of January.
Lordship, before vacation, lordship.
No. Motion or admission?
Admission matters, lordship.
9th of January.
May I please, Lordship? Lordship, I beg to mention a writ petition in motion column, Lordship. Can it be taken up on any date next week? Lordship?
Why is it mentioned for motion?
Lordship, it is in the motion column itself, Lordship. The matter relates to, compassionate.
When was it listed last?
Last on the 19th of this month, Lordship, November, Lordship.
When is the returnable date?
Your Lordship has directed to list it after 7 days, Lordship.
Hmm.
So it's been more than 2 weeks, Lordship.
All right, 5th, Friday, 5th December.
5th December. Obliged, Lordship.
May it please your lordship, with the consent of the other side, I beg to mention item number 4, your lordship.
Hmm.
Lordship, we need a week time to file the rejoinder, your lordship.
Rejoinder. Wait for the matter to be called up. 2017 matter. Yes.
May I plead your lordship, listing of a writ petition for motion, your lordship. For motion, we have filed on 28th, your lordship.
Hmm?
We have filed a writ petition on 28th for motion, listing for motion.
All right, Friday.
Yes, yes. Oblige, your lordship.
Yeah, please also. My lord, I filed one, my lord, writ petition regarding compassionate appointment, my lord. So, my lord, this SLC is going to be held, my lord, as per information on this 10th, my lord. Without leave of this honorable court, my lord, they are not considering, my lord. Because one office memorandum has come, my lord, and this honorable court, my lord, directed to.
What is your prayer now?
My lord, I am paying, my lord, listing of a, my lord, the matter, my lord, Friday, my lord.
Motion matter.
No, my lord, admission matter.
Admission matter. Why?
My lord, it may be a similar order, my lord, maybe disposed of. Time will not be taken much, my lord. Kindly, my lord.
All right, 5th.
My lord. I'm deeply obliged.
May please your lordship. My lord, this is the petition where an order of transfer has been under challenge. My lord, I'll implore your lordship, my lord, to take up the matter for final hearing. It's a further matter.
Huh. Somebody mentioned some video was supposed
Yes,
to
your
be played.
lordship.
What
Let
is that
me-
video?
Regarding the proceedings which happened on 25th of June, because on 25th of June, the petitioner is actually claiming that I had actually given consent that there was basically a stay of the transfer order, and the honorable court directed us not to take coercive action against the petitioner, that is disciplinary proceedings against her. But they are actually trying to add color to that particular order, saying that that is a stay of the transfer order, which I cannot do because this is beyond my instructions, your lordship.
No. Coercive action will mean what?
Coercive action, disciplinary proceeding, because I have.
Was it explained in the court by the court? That
Yes. If your lordship allows me to play that particular video, everything will be clear. Because otherwise, on that day itself,
when was the transfer order? When was the release order issued?
transfer order was issued on 28th of June,
20th.
20. And 20. And the petitioner approached immediately thereafter, after filing a representation.
Then what happened? Release order was issued.
Not release order, your lordship. The petitioner approached the honorable court on 25th itself. The matter came up for motion hearing. And then on that date, the honorable court directed me to not to take any coercive action, but declined to interfere with the impugned transfer order and fix the matter again on 30th of June to produce the record. On 30th of June, my learned colleague appeared, but the records.
When were you informed that the transfer order was issued on 20th of June?
The petition itself says transfer order on issue. It was annexed in the writ petition itself.
No, but then subsequent order, there is a more specific interim order.
Yes, on
Shall not be
21st,
given.
on 21st of July, after the reopening of after vacations, on that date also I did not receive the instructions. But and on that date, lordship, the petitioners had tried to add color to the order dated 25/6/2025, saying that there is an interim order at play wherein the transfer order was stayed. So your lordship stayed the transfer order. I received the instructions on 1st of August. And thereafter, during that period itself, the private respondent, they filed an IA seeking modification of the order because prior to the order dated 21st of July 2025, the private respondent had already joined on 7th of July. That information I received after the passage of the interim order, your lordship.
He should have brought it to the notice of the court immediately.
Yes, in fact, we filed affidavit also. We brought it to the notice of the court. That's why on last occasion, lordship treated this matter as parted. I had produced the records also, wherein on 25th itself, the department itself considered that since the representation is pending, and as per one OM which is in force, the department would consider the representation. But prior to that,
The interim order in respect of the transfer was passed on 21/7.
yes, your lordship.
And you filed your affidavit on 13 October.
Yes, after that, because in the meantime, when the private respondent, they filed an IA. In that IA, the interim order was modified because the private respondent has stated that he had already joined on 7th of July itself, prior to the issuance of the interim order. So your lordships were pleased to order status quo, modify that order into order status quo.
No. Is it?
Yes, your lordship.
Where is that
In the-
order of
IA, your lordship.
IA?
IA number, your lordship, 2985.
IA order bile নাথাকে না। কিয় নাথাকে? কেনেকে গম পাম continuity?
So thereafter, after this order was modified, we filed the affidavit bringing on record each and every fact. Now, what are actually transferred? I wanted to place that video because on 25/6, without instructions, I cannot say that the transfer order is stayed. That cannot happen. I cannot go beyond my instructions. On 25/6, it came for the first time, and I never gave any kind of statement that the transfer order is stayed. The Honorable Court only directed me not to take any course of action because we were contemplating taking disciplinary action against the petitioner because she has not joined the place of posting.
But you said you did not have instructions.
No, your lordship, only
You had instructions that disciplinary proceedings will be contemplated, are contemplated.
that I came to know later on when the records were actually
But you
provided
said,
to me.
why did you give that undertaking?
Your lordship, I did not give the undertaking, lordship. Court directed me. That's why I wanted to play the video. Court directed me not to take any course of action.
We don't know, we go by the order, what is there.
Your lordship, that is there, your lordship, but I never said that I cannot say that there will be no course of action without any kind of instructions, your lordship. That's why I wanted to play the
Anyway,
video.
yes. What is it? The transfer order,
Yes, my lord.
incidents of service.
My lord, I have prepared a list of dates, my lord, that will save it and may at least sit before your worship. The transfer order your worship will give in the writ petition, my lord, at page 13.
Yes.
The first order,
No, what is the defect in the transfer order?
my lord,
It's
my
a-
submission.
You've been in Guwahati for a long time.
Yes, my lord, my lord, the grievance that has been raised is that, my lord, this is an order on request. And this has been sought to be given a color of a, my lord, transfer order in public interest. Now, my lord, so this is an order on the request of the, my lord, private respondent. But my lord, it has been sought to be given, my lord, the color of, my lord, the order in the public interest. Now, my lord, so far as the transfer is concerned, it is for the authorities to decide, my lord, who will be posted where in my lord, in exigencies of service. But here, my lord, when there is a request of one person for his personal difficulties to get an order of transfer, it is the duty of the my lord authorities to consider the comparative hardship of the my lord, the other person who will be transferred. Now, along with the my lord, the list of dates, I have also placed a decision of the Honorable Supreme Court. What is my lord, an order in the public interest and what is an order on request? An order of request cannot be, my lord, said to be an order in the public interest. That is what the Honorable Supreme Court says, my lord. I'll refer to that, my lord. Paragraph 16 to 20 will be relevant, my lord. Now here, in the affidavit we have stated, my lord, the private respondent and the authorities are hand in glove. And this is a stand, my lord, I am taking straight today, my lord. And my lord, in the additional affidavit, if your lordship takes up my additional affidavit, my lord, I have annexed the documents there, which will show that, my lord, they are hand in glove.
Additional affidavit.
Right. This has been filed on, my lord.
2011.
Okay. Which date? Has your lordship got it, my lord?
Affidavit in reply.
Additional affidavit.
Start from page 48.
It starts from page 48. Even the pleadings of the, my lord, private respondent
There's
and the,
no
my lord,
additional affidavit here. There's one affidavit of Dusty Service
no.
and one reply affidavit. And the affidavit filed by the respondent 1 and 2.
For my lord, may I place a copy?
Huh?
May I place?
We'll have to get the copy here. Here doesn't it? Affidavit in reply filed on which date?
Affidavit in reply was filed, my lord. Reply was filed by the. That is much earlier, my lord. On 30th of October, my lord, affidavit in reply.
Affidavit reply to affidavit. Additional affidavit.
Additional affidavit was filed on, my lord,
20th of November.
20th of November, 20.
It's not here. I also.
It has been shown in the record, my lord. 20th November.
In the order sheet, it is not, there's no reflection.
The website it is there.
There's one Dusty affidavit. Then affidavit, this is for affecting service, then affidavit opposition, affidavit reply.
Affidavit reply.
Reply is there.
No, my
It
lord.
is another moment. The website is showing.
The file is not shown.
Can it be called from?
All right, we'll call for it. Matter. You show the particulars to the court master. It will call for. Call for. We'll call for it. Just wait.
I'm sorry, my lord, filing serial number has given, my lord. Tomorrow. Filing serial number has given.
What?
For, my lord,
We are in the middle of proceedings.
I'm sorry, my lord.
Item 2.
Yes.
Lordship, this matter can be disposed of. This matter relates to placing the matter before the SLC. Since there is an order in place, Your Lordship, in WPC 342, and Commissioner's case was recommended by the DLC but not placed before the SLC. So now it can be placed before the SLC in terms of that direction.
Have you seen the affidavit?
Your Lordship, that is there, Your Lordship.
Uh,
But this is the latest round of instructions that I have received. Otherwise, squarely covered by Devabhatra Tiwari. Personally, if I have to say, then
So therefore, I ask you, have you seen your affidavit?
yes, sir. Yes,
Have you?
yes, Lordship.
Kindly point out the relevant paragraph.
Lordship, paragraph number 6.
Ah.
Lordship.
Then they have not replied to it.
They have not replied to it.
Lordship, some time may be granted so that,
16 matter, no time. 2016 matter.
Lordship, 1 week time may be granted.
1 week.
Lordship.
2016 matter, madam. Abdul Kadir Bakshi is with regard to a later petition.
Later petitions. But since paragraph number 9 and 10 said any writ petition which is pending as on date, we place for as a one-time measure. In fact, the latest round of I received also from the district commissioner's office. And now they say that the case of the petitioner was actually
But I don't see what you're saying is reflected in the circular. in
Sir,
this.
in fact the DLC somehow
No, no, you said that one-time measure, it should be sent.
sent.
This is not what is said here.
Here it says that
With this 19.9. Which
19
one are you referring?
19.9, Your Lordship.
19.9 doesn't say so. 19.9 is only with regard to those who have challenged the office memorandum.
Office memorandum.
This is well prior to the office
Well
memorandum.
prior to the office memorandum.
Where does it say that all cases pending were as a one-time measure to
In
be?
fact, that doesn't say, but as the order itself says that any case which is pending, 342,
Challenging the office memorandum.
challenging the office memorandum.
Now, the office memorandum is not under challenge here.
No, no.
It doesn't cover this case.
Yes, Your Lordship can say, take it that way also. Otherwise, Your Lordship, here, in fact, the affidavit of course says that his case, the case of the petitioner was not covered, recommended because her name was of 5% vacancy was not
All
covered.
right, you come back day after tomorrow.
Lordship,
Day after tomorrow.
Lordship.
Heard counsel for parties, the pension is made on behalf of the counsel for the petitioner seeking adjournment for a week. Stop considering that this petition relates to the year 2016, court has declined the prayer made, however. Purely for the end of justice, matter stands deferred to be listed on Thursday. It will be given. To be listed again for admission.
I think we.
Yes, what has happened here?
We have filed our affidavit, Lordship, in 2018, Lordship.
Yes.
And they filed a reply to 2025. And pension papers is already submitted to the AZ Assam in 13.
So they're asking for,
Seven.
they're asking for promotion antedated.
Yes.
Oh, have you considered the application or?
No, Lordship.
uh,
17 যে কথা হৈছে আৰু এতিয়া এটা নতুন কেছও পৰিছে পেনচনাৰী বেনিফিটৰ কথা।
Yes, Mr. N. Deka. This is a 2016 matter. We don't want to give an adjournment. But since the counsel for the petitioner is not here, we want to request you to appear as the amicus. And we want to take it up day after. All right? You'll get the brief from the court master. None appears when the matter is called up, although names of several counsels are reflected in the cause list. So, considering this situation that the matter pertains to the year 2016, the court has requested Mr. Nilanjan Deka, advocate, to appear in this matter as an amicus to assist the court. Matter will be taken up again day after tomorrow. Date will be given. The court master will ensure the service furnishing of the copies of the pleadings to the amicus appointed. Day after tomorrow.
Lordship.
And for response number 6, Your Lordship. Arbor.
The Bora and Arboro for the respondents.
I think for
Yes,
Wait, please, Your Lordship, a last chance may be given to file the affidavit and reply, Your Lordship.
no, first you tell us what is the matter about. What is this matter?
Lordship, in this matter, the petitioner's representation was rejected by the inquiry officer, Your Lordship.
Hmm. Where is your brief? You want to rattle off from your memory? What is your name? What is your name? What is your name?
Jiten Bol.
I'm asking your name.
S. Sarkar, Your Lordship.
All right. You argue this matter on Thursday. Go through the file, come prepared, argue the matter on Thursday. At the request made by MSS Sarkar, counsel appearing for the petitioner, matter stands deferred for a day to be listed again on Thursday. The learned counsel will address the court on the matter. Mr. H. Borua for the respondents. Day after tomorrow, come prepared.
item 6.
Mediation failed.
No, yes, your respondent number 8, I'm appearing on respondent number 8. And I have come to know from the respondent number 8 petition, son, that they have already settled the matter outside the court.
You have settled it.
6. I am the respondent number, and I am the first wife of and the petitioner has filed a petition. Yes.
Yes, what do you say?
Lordship, as my senior is unwell, so
Who is your senior?
Vigadas, Lordship.
Your senior is unwell, you are before the court. What is the subject matter?
Mediation report maybe because I have no knowledge about that.
Why you have no knowledge and why you have appeared without any knowledge?
I'm very
Why?
his junior. That's why.
Well, you are junior, so has he told you not to gain knowledge and appear before the court? Has he instructed you?
No,
So
Lord.
don't acquire knowledge and appear before the court without any knowledge.
I have joined only 2 days before.
So you may join just 5 minutes back, we are not concerned, but you are appearing before the court, you have to address the court. Why, how can you say you have no knowledge? Gain some knowledge, we'll call it up after a while. Go through the file. Go through the file, tell us.
Lordship. Master place, Lordship.
Item 8 and 9.
Additional affidavit. Yes. My lord, to the post of administrative officer, the private respondent is not eligible as per the statute. That, what is that? Revenue, no, revenue, my lord, administrative officer, no, what is that, branch? Branch, my lord, that is in the personal branch, there are two sections. One is establishment, one is account. And the rule provides that it should be, that is, it provides that it should be more specifically for the administrative department.
Pursuant to your lordship's order on 9/8/2025, we have clarified the entire things by filing affidavit, additional affidavit. On
That
9/9/2025.
My lord, I will just place it,
That is the present section.
affidavit that I will place before, they have furnished before this court. All document shows that they are in the accounts department. They were never in the establishment.
Lordship, I have received the instruction, Lordship, on the last occasion on 19/8/25, Lordship. Honorable Court directed us to the open instruction. That instruction I have received, Lordship. Kindly peruse that instruction, Lordship. May I read, Lordship? My bottom portion, Lordship, the works allotment in respect of Rupam Thakuria of personal branch, Lordship, during the said period were operating to pay bills under treated accounts in 2005-2016, Lordship. With reference to the, I have honor to inform you that as per records, Sri Rupam Thakuria had worked in personal account section of personal branch, Lordship.
That is what my
Lordship,
case is.
under the amalgamated establishment deputy commissioner, Lordship. Lordship, kindly see the Lordship, Rule 8(1) of the Assam Ministerial District Establishment Service Rules 1967, Lordship. Here, there's only word establishment is mentioned, Lordship. The district establishment is mentioned, Lordship, not merely personal establishment is there, Lordship.
1 minute. Yes, under the rules, which rule? Rules, my lord,
8(1), Lordship. Roman 1, Lordship.
Roman 1,
1 and
under the Assam Ministerial District Establishment Service Rule 1967.
8(1)(a).
A, my lord. Have served at least for 15 years in any deputy commissioner's establishment and have working experience in different branches in general and in the establishment branch in particular. So, my lord, their notification which shows that the establishment branch is only in the personal branch, establishment section is there. And my lord, they themselves has placed it that he was working in personal account section. Personal has two. One is establishment section and account section. And their documents and whatever it is there, it shows that he is working in personal account sections. And the document that was before the selection committee, that is in 103 of the affidavit, my lord, which is a general certificate issued by my lord, additional deputy commissioner to whom it may concern. Then in serial number 4 also.
Petitioner was working under?
My lord, in the minutes, I am working as a, my lord. Previously, I was working as, my lord, in the appointment in the single, I was, in the revenue department, I was working, my lord, district commissioner's office.
No. Your claim is that there is no experience of working in the establishment?
He never worked.
Department or section or whatever it is.
No, he never worked in the establishment.
Right. And as far as you are concerned?
My lord, in the minute itself, it will show, your lordship will find the minutes that they have, I have annexed in the writ petition also, my lord, your lordship will find it. That is at page 24. The minutes of the meeting of the selection meeting, writ petition annexure 4, page 24.
Number one, the petitioner, extreme right, experience of relevant branch as per biodata submit, personal establishment branch with effect from such and such. And my lord, as regards page 26, the private respondent, personal branch works relating to accounts and establishment. And we have got it through RTI that he never, at page 30, that he always worked in the personal account section, not in the establishment section. So he never worked in the establishment section. And he is not eligible for this post. And the affidavit that my friend just, or the private respondent has stated, he also has given all the documents which shows that, my lord, that he was working in the account section. That is in serial number page 144 onwards. Affidavit filed, my lord, in the month of September. Page 144 onwards. Everywhere
How
it's
many branches are there?
Lots of, my friend was student branches. 29.
How many branches are there?
29 branches.
Where does one get to see these branches?
my lord, in the affidavit, my lord, filed by respondent number 4, page 104. Affidavit filed by respondent number 4, page 104. And the establishment is only in personal branch, 107.
Lordship, to remove the entire confusion
Hmm.
created by the writ petitioner,
Hmm.
I have filed additional affidavit. On, if your lordship permits me, on 9/9/2025, pursuant to the query, pointed query made by the honorable court.
Just a minute.
Ah. Please call up a GAD will please the records and thereafter I will.
Okay, where is your affidavit?
My lord, affidavit, additional affidavit 9/9/2025. Lordship, after the order, yes, page 125. Additional affidavit.
Yes.
Page 125, paragraph 3. That the deponent begs to state that Assam Ministerial District Establishment Service Rule 1967 defines district establishment as follows. District establishment means and includes all non-gazetted ministerial staff in the offices of the Deputy Commissioner, sub-divisional officers, sub-deputy collectors, and block development officers of the district. In the Deputy Commissioner's District Commissioner's office,
Yes, that we have seen. That is our query. That there is no establishment branch separately.
GAD will.
Is mandated by the.
I will establish that point.
Lordship, on the last occasion, your lordship had asked both the government as well as the department to basically find out as to where the establishment branch is. Lord, I had done a little bit of research, my lord, and then found, my lord, and also with the help of the department, my lord. This is from the website, my lord, we have taken out of the government of Assam, my lord, of the district establishment office, my lord. If your lordship sees, there are different branches in the district, my lord, there.
This
So
is for Dima Hasao.
this is for Dima Hasao. It's every district has, my lord. So I've taken out because it was the fastest.
You leave aside Kamrup and go to Dima Hasao.
My lord, I got this, my lord, this thing, my lord. But anyways, my lord, the same thing, my lord. If lordships, all different branches are there, Bakija and all. So we are for the established, we have taken out the establishment branch thing, my lord. So here it's given branch profile, my lord. The establishment branch of the office of the deputy commissioner is a branch that looks after all the matters pertaining to the general administration of the deputy commissioner's establishment.
So where is the establishment branch? You have not shown it in the list.
My lord, this is the establishment. There's this thing separately called establishment branch, and my lord, the functions also given.
Mr. Chakraborty has placed before us.
No, it's instruction, that instruction, Lord.
So, my lord, the functions are basically maintaining service records of office staff, matters relating to pay and allowance of personnel, maintaining tour diaries of officers and staff, matters related to Administrative Reforms Commission, correspondence with personnel
No, you
department, and
bring-
so and so.
If you want to rely on this, you should bring it on affidavit.
My lord, that means
So that they get an opportunity to counter if they want to.
my lord.
What is there in the rules, you are now trying to expand the rules.
So, my lord, in the rules it's given 681 says that in establishment branch, my lord. So, if the experience, if you see in the my lord,
Where is that page, Mr. Roy Chaudhary just saw? The number of branches which are there?
Page 10. Page, it's.
Annexure 11. That
Page,
104.
it starts at page 104.
104. So this is a 2018 notification.
Notification. An establishment section is there in personal branch. That is why in the minutes they have stated personal accounts and personal establishment. That is why in the minutes it is written like.
You have experience in personal establishment.
I have experience and I am senior. And he doesn't work in the establishment. Establishment is only on the personal branch.
Lordship, in the office of the deputy commissioner, district commissioner, Lordship, personal branch consists of establishment and account section, Lordship.
yes, your lord.
Yes.
It's
Come
together.
to page 104. Come to page 104.
Relevant is at page 107.
I have filed. Yes, lord.
104.
Yes.
Relevant page 107.
What does the establishment branch contain? What does the person posted there is required to do?
My lord, the person required there, my lord, has the functions are maintaining service records of office staff. That's what the thing I've given them, my lord. Matters related to pay and allowance of personnel. So these are the functions there, my lord. The functions of the people
He
who are.
worked in the accounts department.
He
He worked in the accounts department, my lord, as well as not only in the account department. The previously, my lord, we had given my lord, your lordship had asked. There, my lord, I'll send it again. My lord. I've got it, one more copy of this. Specifically of the respond number, my lord, private respond number.
Yes.
The experience, my lord, is given over here, my lord. As per the this thing, my lord, experience A, my lord. As per the certificate submitted by Rupam Thakur in his application for the post of so and so, my lord, which has been duly signed by the ADC in Albury. Following observations have been noted, my lord. Experience at Annexure A, my lord. Experience of Rupam Thakuria Senior Assistant Personnel Branch. Rupam Thakuria worked in personnel branch with effect from 17/6/2003 to 18/12/2009. In the office of the DC, the personnel branch includes both establishment section and account section, which works closely together under a common administrative setup. Even though staff may be posted in one section, their works often overlap as they regularly deal with tasks related to both areas. Second, my lord, experience Rupam Thakuria, Senior Assistant Revenue Branch, Subdivisional Planning Branch, and NRC Branch of DC American Establishment. The Rupam Thakuria had worked in several important branches of the DC, including Revenue Branch from 25/2/21 to 5/3/24. Then Subdivisional Planning Branch, Food and Civil Supplies and Consumer Affairs from 9/12/2009 to
All
2/3/2009.
this we have been a part of the affidavit.
My lord, we have given in the affidavit also, my lord. But
This one-
additionally, your lordship had asked for this, my lord. What is his experience? So we have got this, my lord. On last occasion, my lord, could not be taken up because my lord, the respondents have taken time, my lord, private respondents. This we have got it, my lord. The full training is then training in accounts and establishment matter, my lord. The crucial C. The A and C are crucial because both personnel and the account and establishment matters come under the establishment branch. And my lord, Rupam Thakuria was deputed to undergo a 4-month training at the Central Institute of Training, Directorate of Accounts and Treasuries, Assam. the following subjects are this thing. So
No,
these are-
these documents show that he has some experience.
Yes, sir.
not
My lord,
totally without
whatever
experience.
documents they have submitted, my lord,
Uh,
will show that he is always in the accounts, never in the administration.
Part of the establishment, Lordship.
both are.
Either you finish or I finish.
No, firstly, there is no specific establishment branch.
My lord,
Correct.
establishment
That is-
section.
No. There is no establishment branch.
Right.
What is there is establishment section.
Section. And it
that
is includes
under
in the personal branch.
That is under the personal branch.
Branch.
Ah.
And the respondent number 4 in the personal
So
branch.
therefore, the mandate of the rules that say that you must have experience in establishment branch in
Right.
particular, can it be interpreted to mean at establishment section?
My lord,
No.
if not that, it cannot be said that he never worked in the establishment.
If it
Our
is-
statement is,
If it is not there, it is not there.
my lord, he has always worked in the accounts, but he never worked
Your
for,
ground-
never in the
Your-
establishment.
Your ground for challenge is that the rules are violated.
They are not eligible. He is not
They're
eligible.
not eligible.
Not
Because the rule says you work everywhere, but establishment branches in particular.
In particular.
But the administration does not have an establishment branch.
Because, my lord, establishment, the language is only branch, but it is, establishment is in the notification.
Hmm.
This is of 67 rule and the notification came in
So
2018.
the government has given these
Notification in
these
2018.
these instructions which clearly show where they make a categorical statement that both establishment section and account sections are working closely under. the
Now they
common
want
setup.
to, my lord, how could only, my lord, when the document which was before the authority, that only to whom it may concern at page 103, where it shows that he worked in the, my lord, your lordship may look into page
Sir,
103
Mr.
there.
Mr. Counsel, what we are to see is whether the decision of the
Authority
authorities is
is
so irrational.
irrational or
that
absolutely
it calls
purpose.
for an interference.
My lord. That itself I will show you before lordship, my lord, that it is written, always written is accounts. Only accounts and establishment. Only accounts and everywhere it is accounts. Nowhere, my lord. In my case, my lord, in the minutes, it is there only establishment. And his case, it is only accounts, my lord. No establishment. Now they want to, after giving,
Where are the minutes again?
my lord, minutes are at page in my petition
Page number 13.
24. In my case, it is personal establishment branch. Establishment branch, page 24. And in the case of private respondent, personal branch works relating to accounts and establishment. Page 26. And my lord, the certificate that,
But let us say that you satisfy establishment branch.
my lord,
It appears that you are working only in the personal establishment branch.
my lord, establishment.
The rule says that you must have experience in different branches.
In different branches.
Ah.
That is also, my lord, I have given, my lord, I have worked in different branches.
The remarks doesn't say so.
My lord,
Page number 24, the remarks column.
because my lord, they have just given this, and my lord, in case of the page 26, they have given administrative branch with effect from. And my case, my lord, my certificate that I have annexed in my affidavit. I've given my chart, my lord. My lord, I have given in page 9, paragraph 8,
The writ petition.
read petition.
That way, the private respondent has also worked,
But not in the establishment, never in the
except for the establishment.
except for the establishment. That way, he is also working in different places, but not in the establishment. Always in the
So
account.
therefore, the mandate of the rule to say that it is under the establishment branch will be applicable when the establishment branch
Well,
is
because
available.
after it was of 67, then it was not amended. Then came the 2018 notification. Notification says personal branch, two sections, establishment section and account section.
Where is the notification?
104 page.
That is given by our.
And your lordship will find there are 29 different branches for which one is personal, which only includes establishment and accounts. And the word establishment is nowhere in other 29, other 28. If I take away personal branch of 29, and establishment is nowhere. And they are admitting to that fact.
No. So he's also working under personal branch.
Personal accounts.
So therefore,
Accounts is a part.
whether your experience in personal accounts or establishment or conduct discipline is important for you, is an important
my lord,
criteria.
your lordship,
One has to go by the rules. The rules are very clear. It says
Yeah.
personal branch.
my lord, personal more particularly,
there's
because
no-
during that time,
No.
personal establishment branch was there.
It does not, during that time, what was the personal branch comprised of?
My lord,
Is it a
during
mix
that,
of
in
it?
67, there was no personal branch.
No.
There was only establishment.
I'm sorry, the establishment branch, what was it?
In
What did it
1967, that
comprise?
was only establishment branch.
What did the establishment branch comprise?
So that is not there in the rules.
That's right.
And my lord, your lordship may just, the affidavit they have filed in September, page 144 onwards, all those annexures your lordship will look into. Page 144, annexure 12 onwards. It is the respondent number 4's documents.
144.
144. Respondent number 4, they have filed it, my lord.
Hmm.
Your lordship will find the first document, it is accounts. Then, my lord, your lordship will find at page 146, again accounts. Then, my lord, 148, it is again training for accounts. Is always on the accounts, my lord. Then, my lord, at 150, it is
What is the nature of work you do in establishment?
establishment, man, it is given in, my lord, the works that are enumerated in 107. Establishment includes, my lord, conduct and discipline and other general condition of government servants, administration of implementation of Assam Right to Public Service Act 2012, the Assam Ministerial District Establishment Rules such and such, Assam Financial Rules, Assam's Disciplinary Appeal Rules, Fundamental Rules, Assam Service Pension Rules, Delegation of Financial Powers, Assam Revised Leave Rules, and the accounts sections deals with minutes relating to pay and allowance, matters related to special audit, matters related to committee income tax, such and such. So there are the bifurcation of works are there. You just, they cannot say, because under the Assam Service Manual, there are different service rules are there. So they are saying about the head note of personal branch. But he worked in the personal branch account section, never in the establishment.
There was a judgment, I think this bench had delivered.
One judgment, yeah, last I have got it that. Yes. Your lordship will, that is.
Yes, yes.
But it is 2024 5 GLT 275. Bhubaneswar Sharma.
The issue was different.
2024
5 GLT 275.
issue was different. Bhubaneswar Sharma.
That was, my lord, a case where, my lord, the revenue Shahidar, my lord, that was the, my lord, regarding RS post, my lord. The advertisement for the was for the RS post, and the person who had more experience in revenue was selected, my lord. So that was the issue there.
Because there also that question came, who worked more in what department? The question arises in
Yes,
that court and
I was
ultimately
in that
court
matter,
held
my
that.
Let us see.
my lord.
It is your. No.
From para,
What is that? Bhubaneswar?
Sharma.
Bhubaneswar Sharma, 24/5 GLT 275. From para 20 onwards, madam.
Where is the best chance?
Para 20 onwards, my lord, your lordship has given now.
Me, short time learning, executive data, the one week learning.
You will see the ratio of that case, man.
This was upheld by the division bench.
Yes, your lordship. It was,
We are bound by our judgments.
My lord, here your lordship will find, I understand, my lord, but your lordship in para 21, your lordship will find.
They explored and it was upheld by a division bench that.
My lord, but there was a
scope of
case.
judicial review in this.
There was a case, my lord, where in para 21, your lordship will find that upon careful perusal of the records and material available therein, it is seen that the respondent number 4 had rendered 21 years in revenue branch as compared to the writ petitioner. Whether this is a valid criteria, but my lord, here what our contention is before your lordship is this: he never worked in the
prescribed, the authorities have found that to be sufficient.
Because, my lord, the documents that the record was called upon, the document that was placed,
Hmm.
even itself shows that he was in the accounts. The document at 104, I think, my lord. In the documents of 104, you'll also find. 104, yes, that's a little page.
Yes.
My lord, the documents that is at page 103. To whom it may concern, that was before the selection committee. And my lord, the RTA that we have got it through in the writ petition. Your lordship may just first peruse our RTA. That is at the last page of the writ petition, page 30, annexure 6. Your lordship will find, with reference to the above, I would like to furnish her with the required information sought for. My lord, as regards the respondent number 4, in serial number 4, personal account section branch DC office Nalbari. You in my lord, page 30, annexure 6.
My lord, the whole question is whether authority can, this court can sit on appeal, or whether authority has selected to be.
He can if he want to.
Lordship, but
He can if he want to.
but no, not in this type
If
of.
we
a
find
way.
that, yes, the selection is not up to mark, we can interfere.
So our point is, my lord, we have sufficient experience. We have elaborated in our additional affidavit.
6 years.
6 years.
All right.
My lord, just
So then-
for lordship's
But the writ petitioner, even her graduation is under challenge. She took that graduation violating that conduct rules, section 13. But we are not urging those points.
before
This
I
is a post where merit comes suitability, not seniority.
my lord, before I conclude, can I trouble
Yes.
your lordship to 2 pages, my lord? Only at page 30, annexure 6 of my writ petition, my lord. My lord, your lordship will find it is through RTI proper procedure, we have obtained the experience of the private respondent. That is at serial number 4, personal
No,
account
but
section.
who are we to judge?
My lord.
Whether your experience or.
No,
his
my lord, I am not
experience.
asking for the experience. Whether he has ever worked in the
That's what the
establishment.
department said.
But department says, my lord, if it is expressly proof that that was only just to somehow give him some.
The rules mandate a criteria which is not in force.
Not in force, that was subsequently came into by this notification. Notification says that it is 2018 establishment has been included in the personal branch, and there are 2 sections, accounts and
No, but the notification does not elaborate on the rules.
non rules,
Notification only
because
lays
it's
out
the
that what are
67
what are
rules,
the
my lord.
criteria again.
Previously, there was a separate branch for establishment. Now, establishment has been included in the personal. There are 2 sections, accounts and establishment. Now, he was working in the accounts.
Same thing. Lordship will go through the experience.
Let me finish. My lord, your lordship will look into page 30, annexure 6, where your lordship will find that that is through RTI. That is only accounts he has worked. And my lord, at page 103 of their affidavit, the document what was before the selection committee, that also says he worked in the accounts. Just to give him the eligibility, they have used the word and establishment. Page 103, just to give him his eligibility. And all his document shows that he has worked in the accounts. And this document was before the selection committee.
Yes.
That is what my submission is. And my lord, one judgment, your lordship, my lord, we have not brought it, my lord, just now, my lord, one judgment was there, my lord, 19.3 SCC, page 422. 19.3 SCC, page 422. As regards eligibility condition. Page 422. 422. Paragraph 17, 20, 21, 23, and 24.
17.
20, 21, 23, and 24. Page is, my lord, 19.3 SCC, page 422.
What's the name of the parties?
Party's name is, my lord, Ritu Bhatia versus Ministry of Civil Supplies, Consumer Affairs and Public Distribution. Ritu Bhatia.
Let's have a look.
Just come on.
What are the facts here?
My lord, as regards the appointment of a company secretary, my lord, in a PSU, public sector undertaking company, was working as a management trainee, whether that will be considered as a experience, my lord.
This is a case of promotion.
Promotion, my lord, by eligibility. I was just on the ratio of eligibility.
No, this is a promotion.
Promotion, but
Was there any specific criteria notified before the promotion?
the advertisement showed, my lord.
There was advertisement.
Here in this, my lord, in our case, my lord,
Huh?
my lord, there was, my lord, I think, my lord,
There was an advertisement.
Yes, sir.
page 20, annexure 1.
Or affidavit. Page 78 of our affidavit. First affidavit.
It says any of the establishments.
Yes,
Yes.
yes.
But the rule provides, the amendment rules
You
also provide.
participated.
Yes.
You participated.
My lord, to sum up the notifications, my lord, I will take your lordship. The notification they have annexed as that was subsequently given, my lord. I'm just placing that total notification. In fact, what? My lord, at page 43,
Yes.
Page 43, Annexure D. This is an affidavit by my lord, Joint Secretary, Government of Assam, Secretariat Administration Department. Amendment of Rule 6 in such and such, then 8.1. May I read it, my lord, slowly? The post of administrative officer shall be filled up by selection from amongst the posts.
Page number 43.
43, Annexure D, affidavit filed by Babul Lekhao, Joint Secretary to the Government of Assam, Secretary Administration Department.
Second to know, second.
Respondent number 3.
3, man.
Yes, page number
43. That is of my lord, 2nd March 29, General Administrative Department notification.
No, 43 is 24/5/2022.
My lord, here,
This is by Asraful Amin.
but here in my case, my lord, they have given this annexure D, page 43.
No, affidavit filed by whom?
Affidavit filed by my lord, Bubul Lekhwa.
No, this is something else.
WBC को कैसे 150 का तो expect किया had this idea I think 80 के साथ नहीं करा 82 to 1 6 for 3 into just 6 for 6 I mean repetition number को it was said
In repetition number 658324. The present case, in the present case.
Babul Lekharu or something.
Your lordship got it?
Yes.
My lord, annexure D.
Yes.
My lord, 8.1, your lordship will find in the, by this notification, 67.1 has come into being this way. The post of administrative officer shall be filled up by selection from amongst persons who have served at least for 15 years in any deputy commissioner's establishment and have working experience in different branches in general and in establishment branch in particular, and have possessed a graduate degree in any discipline from a recognized university in India. This is what the present scenario is. And the next page, my lord, vacancy of all those things.
No, this is an amendment.
Amendment.
But it was already there.
It is already there, but amendment also shows this way.
Or this is a part, this is pursuant to the amendment, is it?
My lord.
advertisement 21
In this book, my lord, this has come after amendment.
It has put in the amended portion.
My lord.
Prior to amendment is not there for it.
Not there. Can I conclude?
Lordship, as far as the department is concerned, my lord, I have again, Lordship comes to the instructions which are placed today, my lord. There, my lord, regarding the experience, the whole thing I had not read out, my lord. Just once I want to point it out, my lord, before.
Instructions.
Today, my lord, I have given the 16.8, dated 16.8.25, the instruction which I have sent.
16.8.
My lord, kindly see. Forward it.
14.8.
16.8, my lord, It's given, it is addressed to me, my lord, and then my lord, it will comes to the third page, starting from the fourth page, Annex A. The lordship, I read it that time, lordship was seeing.
We don't know where it was coming from. We have one set 14th of August 25.
No, that's this one. 16 not listen. 16 That is.
What is the second writ petition for? 1338?
My lord, the first one was, my lord, wow, the minutes was challenged. Thereafter, my lord, during the pendency, the impugn order come over that, then we offense.
Is there an interim order?
No, my lord, no, sir.
My lord, suppressing actual material facts, what does the court's order as subsequently this writ petition?
Huh?
While filing the second writ petition, they have suppressed vital thing, facts.
Yes,
We have also objection of how the second writ petition has been filed.
Yes.
So, my lord,
So your lordship comes to the third part, my lord, where I read the B part, my lord. Third page, Annex A. Training in accounts and establishment. Rupam Thakoriya was deputed to undergo 4-month training at the Central Institute of Training, Directorate of Accounts and Treasuries, Dispur, with effect from 14/5/2007 to 14/9/2007. The following subjects were covered during the training: FRSR, my lord, the Assam Services Discipline Appeal Rule 64. Then, my lord, Reeve Rules 1934, GPF rules, Pension Code, Treasury rules and subsidy rules, Assam Financial rules, Traveling Allowance rules, Assam Fiscal Responsibility and Budget Management rules, Delegation of Power rules and Budget Management. These subjects are equally essential for both establishment and accounts, my lord. You'll note this, my lord. Sections under the personal branch. So both, my lord, the establishment accounts branch are under the personal branch. Then, my lord, Rupam Thakoriya passed his examination in grade 1, held after completion of the training, and was granted 2 advance increments, my lord. Thereafter, my lord, will come to D, my lord. Rupam Thakoriya underwent training program from 19/8/14 to 23/8/14, organized by the DC Nalbari as instructed by the Assam Administrative College so-and-so on office procedure and financial market management. The training covered so-and-so subjects such as Assam Service Discipline, departmental proceedings, cases, leave rules, maintenance of service books, pay fixation, GPF rules, procedure of appointment and roster point, pension and matters, and FRSR, which are equally essential for both the establishment and the account sections, my lord, of the personal branch. Then, my lord, E, this is crucial, my lord, again. E is my Rupam Thakoriya, office of the so-and-so, in connection with the revised pay of fixation 2010. Along with some other staff members, fixation of pay is fundamentally an establishment matter, my lord. So that, my lord, but due to his experience, he was entrusted with this responsibility. So he was given that responsibility as well, my lord. Thereafter, my lord, you'll come to the last part, my lord, which is signed by the DC Bajali. Thus, Rupam Thakoriya's experience in establishment work across these multiple functions, branches, make him fully eligible for consideration for the post of AO. Since he has, my lord, establishment as well as accounts, my lord, both. He and my lord, if your lordship, previous occasion, my friend, my lord, had placed the record. There, my lord, itself shows that he has got, my lord, 6 years, 8 months experience in establishment as well as in personnel. And whereas the petitioner has got 2 years, 4 months, man. And the ACR also will be crucial, my lord. I mean, he'll be placing the record again, my lord.
What records?
The record which has the minutes and everything, all the documents regarding the petitioner as well as the private respondent.
Okay.
And the ACR gradings as well as, my lord. So ACR gradings also will be crucial, my lord, of both the petitioners and the because in the other case also, my lord, which my senior has placed, my lord, there also, my lord, had seen the ACR gradings. Which
All right, if time permits, we'll dictate it today in court or on Thursday.
my lord.
Heard counsel for the parliament. Reserve note dictating to them. Sentences. Either today, second half, or on Thursday.
My lord.
You inquire from the court also.
by subsequent affidavit may kindly be taken into account. What the otherwise it will be repetition only. Pending item 1.
Your Lordship will kindly take up my additional affidavit. Your Lordship kindly comes to page 55. This is a letter, communication by the respondent number 3 to the Registrar Industrial Tribunal Dibrugarh where he was working. My lord, sorry, my lord, he written to the presiding officer. Now, your Lordship may skip, my lord, last but one sentence, your Lordship will kindly read, my lord. Therefore, I request your honor to allow me to move to Labour Court Guwahati to hand over charge of Registrar Industrial Tribunal Dibrugarh to Srimati Poli Court, the petitioner, Registrar Labour Court Guwahati and vice versa. So, my lord, he requested the presiding officer that he may be allowed to move to Guwahati to hand over charge to, my lord, the petition. Then on the same day, my lord, page 56, your Lordship will find, my lord. This is a, my lord, by the Registrar Industrial Tribunal, he has written, my lord. With reference to Rule 145 of the Assam Financial Rules, we, the undersigned, have the honor to report that we have this 5th July 2025 at 5 p.m. in the forenoon afternoon received and handed over charge of Registrar Industrial Tribunal Dibrugarh in the district of Dibrugarh as per the Government of Assam notification number such and such dated 20th/6/2025. That is the transfer order. Your Worship will notice, my lord, he makes a request to the presiding officer that he may be allowed to move to Guwahati to hand over charge to me. And on the same day, in the afternoon, my lord, he says that charge has been handed over. Then, my lord, the next page, page 57, your Lordship will find. This is a, my lord, purported joining report. Second paragraph, your Lordship may read, my lord. May I further state before you that wide later dated 5th July 2025, I have handed over the charge of Registrar Industrial Tribunal Dibrugarh in order to take charge as Registrar Labour Court Guwahati, which has been duly seen and allowed by the presiding officer Industrial Tribunal. Now, the, my lord, presiding officer of the, my lord, Labour Court here writes to the government regarding this, my lord, application of the respondent number 3. Second paragraph, your Lordship will find, my lord, it is pertinent to mention here that since Srimati Poli Court's Registrar Office of the Labour Court Guwahati has opted for earned leave with effect from 21/6/2025 till 10/7/2025 without handing over charge, and the fate of her leave application is not known as of yet, as a result of which the post of registrar is lying vacant in the office of the undersigned, and as such, the joining of Sri Bidyut Kumar Das is accepted accordingly. Now, my lord, here, my lord, this is an indication of the, my lord, as I was saying, my lord, their hand in glove and malafide is there. A person, my lord, who is on leave, that has been, my lord, said to be a post lying vacant. And, my lord, he has been purportedly allowed to join. But then, my lord, your Lordship will kindly see page 59. Next page. This is a communication from the presiding officer, Industrial Tribunal Dibrugarh, to the presiding officer of the Labour Court at Guwahati. This is important, my lord. With reference to the subject cited above, I have the honor to state that as per the email received on 8/7/2025 from your office regarding certificate of transfer of charge by memo number such and such dated 5/7/2025, showing purportedly that the Registrar Industrial Tribunal Dibrugarh has handed over the charge of Registrar Industrial Tribunal Dibrugarh here at Industrial Tribunal Dibrugarh, but actually he has not handed over any charge in this office of the Industrial Tribunal Dibrugarh. Now, your Lordship will see the, my lord, sequence of events. He first makes a request to the, my lord, presiding officer at Dibrugarh that I may be allowed to go to Guwahati to hand over charge to me. Then, my lord, on the same day, my lord, he purportedly hands over charge. And then, my lord, he comes and, my lord, purportedly joins here without handing over charge, which is reflected in this page, my lord, 59 order, my lord. Now, this makes it very clear, my lord, that he is a very influential person, my lord, Only thing is perhaps, my lord, he could not influence the presiding officer of Dibrugarh. Now, so far as, my lord, the nexus between the department and the, my lord, petitioner is concerned, I'd like to point out, my lord, I have stated in my affidavit very clearly. There are, my lord, some paragraphs in the affidavit of the, my lord, department and the, my lord, affidavit of the private respondent number 3, which are, my lord, exactly same, my lord. For instance, my lord, in the IA, which has been filed by the, my lord, private respondent number 3 for vacating the, my lord, interim order, there the paragraph 5 and the, my lord, paragraph 5 of the affidavit in opposition of the government are exactly same, my lord.
That IA is already disposed of.
My lord.
Now,
No, what I am on is that I have taken this ground in my affidavit, my lord, that they have quoted whatever is there, my lord. The entire story has been, my lord, given in the manner, my lord, the word to word is same, my lord. This, my lord, reflects that, my lord, they are, my lord, they have nexus, and my lord, the presiding officer here has taken a partisan view without handing over charge at Dibrugarh. He has come and he says that I have joined. That's why, my lord, the prayer was made to produce the records. Records will reveal, but these documents are there, my lord. Now, my lord, my submission before lordship is that the transfer order has been said to be in the public interest, but it is not in the public interest. And for that, my lord, on that point, my lord, I am relying on the decision of the Honorable Supreme Court. And my lord, if it is not a, my lord, a transfer order in the public interest, then, my lord, comparative hardship has to be, my lord, considered. May I take your lordship to the judgment, my lord? I have annexed the list of dates. I'll read only, my lord, 3 paragraphs.
take us through the judgment. It's not a very long judgment. It's
No,
not
my
a very
lord.
long judgment. Take us.
I'd like to rely on paragraph 16, 17, and 18. May I read it? The purpose and object of transfer in public interest is singular and straightforward. That is to ensure effective and efficient administration. This is for the reason that the administration and provisioning goods and services in a welfare state requires the government to deploy officers at different places, and the exigencies of service take within its sweep the need to redeploy or transfer them from one place to another for myriad reasons, all intended to subserve the purpose of the state. All these decisions are transferred in public interest. On the other hand, where a transfer is sought at the request of the officer, and if the government is satisfied with the genuineness of the request, it may accept the request and direct transfer. This is fairness in action as governmental power accommodates, as it must human needs and vulnerabilities. However, this kind of transfer effected at the request of an officer does not partake the character of a transfer made in the public interest. Transfers characterized as in public interest are founded, sourced, and rooted in administrative exigencies and nothing else. Affecting the transferring employee at their behest is equally important, but exercise of the power and discretion is to subserve a different cause or value which is distinct from transfer in public interest. It is necessary to draw a clear distinction between these two, as their purpose and procedure and the consequence are distinct. The distinction is in the fact recognized and incorporated in the rules. If a government employee holding a particular post is transferred on public interest, he carries with him his existing status, including seniority to the transferred post. However, if an officer is transferred at his own request, such a transferred employee will have to be accommodated in the transferred post subject to the claims and status of other employees at the transferred place, as their interests cannot be varied without there being any public interest in the transfer. Subject to specific provisions of the rules governing the service, such transfers are generally placed at the bottom below the junior most employees. So that is not relevant. Now, my lord, my submission before your lordship is that from the documents that I have placed before your lordship, it is clear, my lord, that this transfer is not in the public interest. And therefore, my lord, on this ground alone, the transfer order cannot stand. And my lord, further, my lord, in the pleadings, I have clearly stated, my lord, that there, my lord, they have nexus, and without, my lord, handing over charge in Dibrugarh, he claims that he has handed over charge here, and he claims that he has joined here.
Where is the records relating to the transfers?
Your lordship, I have it.
We'll just quickly go through the records.
Yes, your lordship, this flag mark F is important with regards to handing and taking over a charge for the petitioner as well as the respondent number 3.
The request made by the petitioner.
Yes.
So how is it a
No,
public interest?
request of the petitioner, she has filed a representation against the transfer order.
Huh?
The
Not
petitioner,
petitioner, the private respondent.
yes, the private respondent had earlier in the year 2021,
Hmm.
he had earlier made a request for transfer. That was turned down by the department in 2021. Thereafter, again, after spending around 7 years in Dibrugarh, he again filed a representation. This time the department considered the representation.
So you have to justify how is it public interest?
Your lordship, that is what, affidavit, your lordship, if your lordship persists,
If you can't explain, you have to show it from your records.
your lordship, that is why it was done in public interest. Your lordship, what we have stated in our affidavit, if your lordship peruses just to one line. At paragraph number 5. Last second line.
Just a minute. What is the nature of service here? You are the registrar.
Registrar.
Registrar of
Labor
courts.
Labor courts and industrial tribunal.
So what is the tenure?
Normally it is 3 years. Normally it is 3 years, but petitioner, he has spent around now 13 years in Guwahati. And the petitioner, he has spent around 7 years. So the petitioner, he is on the verge of retirement and he had a 85 years old ailing mother.
Petitioner or respondent?
A respondent, I'm sorry, respondent number 3. Respondent number 3, he filed an application on 25/2025, citing his age-old 85 years old mother as well as his son. And the department this time, because he had cited the same reason in 2021, it was not acceded to. In 2025, since he was on the verge of retirement in the month of February 2027, as a last leg tenure, he belongs to Nagaon. So considering his nearby place of posting to take care of post-retirement duties, the government acceded to that particular request and issued a transfer order. Now the petitioner, she had never served in Dibrugarh. She had served only in Silchar and Guwahati during her whole service tenure. So, and the other post which is covered in Guwahati, the other person, he had already served in Dibrugarh. So for the department, the natural choice was to transfer the petitioner since she has never served in Dibrugarh. Now, in fact, there is the petitioners, they are saying that this particular impugn order only includes the name of only the petitioner and the respondent and no one else. In fact, we have in the records itself, the earlier transfer order is at flag mark C, wherein the petitioner was earlier transferred in the year 2012. Only the petitioner was transferred from Silchar to Guwahati. Then they did not have any kind of problem. Only now they have a problem because the petitioner and the respondent number 3, they have been transferred. Now, we have stated in an affidavit that normally the department takes into consideration the private request of the employee concerned on various, for various reasons, including for taking care of the marriage, for the family obligations, for the health reasons, and all these reasons I actually request are acceded to, so that the government servants can balance the work-life balance. And this would actually go on to bring administrative efficiency.
Now, from where are you making all these submissions?
Your lordship, from the affidavit, sir.
So affidavit is based on what materials? Who has filed the affidavit?
The affidavit filed by the department concerned.
So department has made all these statements on basis of what? Is it circular, rules, office memorandums?
Your lordship, on
the
earlier
work-life
occasion,
balance?
on earlier occasion, when the matter was heard, they had actually raised this issue that this was done at personal request.
Yeah, of course, that is what your
So
records say.
now also, then on the basis of that particular direction which fell from your lordship, we had filed an affidavit as to what was the reason for transfer.
So, but where is the reason in the records? That's what we are trying to find out.
Your lordship, in the records itself, the reason is given in the it's in flag mark F itself. The consideration of the representation. Flag mark E and flag mark F. So regarding handing taking over charge, the department had directed no need to wait for the reliever. Immediately join because there is an OM in place. OM says you join in the place of posting and then we'll consider the representation. I have annexed that OM also in the affidavit. And we will consider. There's no difficulty in considering the representation, which is pending right now before the department concerned. We review the pendency of this particular writ petition.
And what rules are your service governed? What rules govern your service?
My lord, there is no specific rules for the, my lord, the Department of Labor. So it will be, my lord, under some service disciplinary appeal rules.
No, service rules, not
They
disciplinary.
don't have a service rule. To my knowledge, they don't have a service rule. Oh.
Generally, department follows the Department of Personnel instructions regards to transfer.
So this is not in the interest of public service.
Your lordship, it is in the interest of, because your lordship, if I may place one judgment, I have placed one judgment earlier. Shilpi Bose versus State of Bihar. Perhaps it is there in the records, lordship.
What is there a policy of transfer in place?
Yes. Policy with regards to, because there is one policy that every government servant has to.
Where have you discussed all this?
Yeah, your lordship, in our affidavit itself.
No, in the orders, in the files, your affidavit will explain whatever you've done. We wanted
Yes.
to see what is being done. Somebody gives an application, we are not saying it is misplaced. Somebody has some difficulty. Now, the petitioner has again given another application giving her sets of reasons. How will you decide it?
Your lordship, that is what, your lordship, we would consider the request of the petitioner. If your lordship kindly peruses through our affidavit, there is one OM to which we follow, which the department follows. That is the OM dated 25th of November 2024, which is an annexure 3, page 28 of our affidavit filed by the department, respond number 1 and 2.
Yes.
This relates to timely handing, taking over and taking over charge
that
and
we have
transfer
seen.
and posting.
That we have seen.
So the question of
We are
transfer,
asking you that in the records, there is no reasons available except approving the request made by the private respondent.
yes,
You may be correct in considering the request having worked for 7 or 8 years in the same place, some personal reason. Now there is another reason given by the respondent to recall that order. How will you decide it? On what basis?
your lordship, the respondent, I'm not getting this last part, your lordship, what the respondents have stated, but the records will reveal that the reason, the representation of the respondent number
See,
3 was
it is
taken into
not- it is
consideration.
Not as per a policy that you are relying on to say that we are transferring officials after 3 years, 4 years, 5 years, nothing like that.
Nothing like that.
It's a case that he was there, she was here, he filed a representation, earlier it was rejected, this representation came up and it got approved.
Approved.
And this order has come out as public interest. What is public interest?
Your lordship, that is what, that's why I wanted to place this particular
Please.
judgment.
Please it.
Shilpi Bose versus State of Bihar.
Okay.
There I would like your lordship to kindly go to paragraph number 3. There the fact situations are discussed. And
Citation to the.
last time they should have copied. AI 1991 SC 532. Next paragraph number 3, next page, if the second page of the judgment. If I may start from the bottom of the first paragraph itself, if the competent authority issued or transfer orders with a view to accommodate a public servant, from that line. Has your lordship got
Paragraph number?
first paragraph itself? From the line, if the competent authority issued transfer orders.
First paragraph.
First paragraph.
First paragraph is leave granted.
First paragraph, no, your lordship, second page of the judgment.
Huh.
Paragraph number 3.
Yes.
From the bottom, 8th line. If the competent authority issued transfer orders. If the competent authority, if I may just read out, your lordship.
Yes.
If the competent authority issued transfer orders with a view to accommodate a public servant to avoid hardship, the same cannot and should not be interfered by the court merely because the transfer order were passed on the request of the employees concerned. The respondents have continued to be posted at the respective places for last several years. They have no vested right to remain posted at one place. Since the whole transferable post, they are liable to be transferred from one place to the other. The transfer orders had been issued by the competent authority which did not violate any mandatory rule. Therefore, the High Court had no jurisdiction to interfere with the transfer orders. In our opinion, the court should not interfere with transfer orders which are made in public interest and for administrative reasons unless the transfer orders are made in violation of any mandatory statutory rule or on the grounds of mala fide. Now, a government servant holding a transferable
Where
post,
are your rules?
that is what, your lordship, if suppose there are no rules also, this line is important. A government servant holding a transferable post has no vested right to remain posted.
We are agreeable with that. What we are asking you is that on the basis of an application, you have merely approved that application and issued the transfer order.
Yes,
Now there is a corresponding request given by the petitioner, and your ground is you come and join, then we'll answer your
yes.
prayers. The question is that other than rejecting that application, what other orders can you pass in the absence of any specific set of rules, set of guidelines
Your
as
Lordship,
to your transfer policy?
Your Lordship, there are no rules as such. They only took that particular request because the petition, the respondent number 3 was retiring. Only on that particular
So
ground
in
and
the
on the
absence of
hardship.
this, how can you say this is a public interest?
Your Lordship, only
In
because
the absence of the reasons given there, how can you say it is public interest?
that is what Your Lordship, in an affidavit that we have stated
You
that
can't
if
expand the reasons by way of an affidavit.
I understand, I totally understand, Your Lordship. MS Gill is there, but at the same time, Your Lordship, the department has just clarified this issue. They are not expanding the ambit of the
How can
order.
they clarify what is more than in the records? Records will have to reveal.
Your Lordship, as Your Lordship,
Records will have to reveal that, yes, these are the reasons.
Your
We are
Lordship,
not suggesting you reasons, but you could have very well given the reasons that these are the reasons, these is the parameters under which we are required to operate.
I believe they have given the reasons in the records.
And their reasons
The
are there,
reasons are
but the
there.
reasons are only considering the application made by the petitioner.
Respondent
Number 3. That's the only consideration.
Yes. Before
And it was approved.
before
There are
yes.
no reasons. It's approved.
Your Lordship, it shows approved, but I think the reasons were there in the
No, there are no reasons
note
here.
sheet itself.
In the
Note sheet itself.
in the note sheet only we are referring to. The note sheet reflects the projection given by the section officer in respect of the application.
Yes. And that was
And that
approved.
was approved.
That was approved.
So these are not reasons.
I agree. There are no reasons to that effect.
Then how do you say this is a public interest? In the absence of any reasons.
Your Lordship, that's why we have clarified the affidavit
You
stating
can't
that
clarify. How can you clarify something which is not there in the records?
because this specific question was directed to us as to how it is on
If it is not
public
there, it
interest.
is not there.
Your Lordship, if suppose the administrative efficiency is established, is to be achieved,
Where
is
have
what-
you stated these with reasons? It can't be in your affidavit.
I agree. That is not there in the record itself.
Then
Just it says this approved.
yes, Mr.
I think I will should not take much time of this honorable court, my lord. The only thing, my lord, I submit that the decision relied upon by my learned friend, that is where, my lord, the person was transferred to a rural area, and my lord, there is no question whether it was in the public interest or not, or it was on the request. So, my lord, that the facts of that case, my lord, does not apply to our case. And my lord, when the records are clear that this is not in the public interest, it is on request, it could not have been given the color of my lord, public interest, and on this ground itself, my lord, the transfer order has to
Now,
go.
what difference does it make whether it is in public interest or is in personal request?
My lord,
Supposing we say, supposing they had issued the order, that it is on the personal request of respondent 3 that this transfer order is issued.
now that would have given me ground to challenge it on that ground, my lord. Why don't you have, consider the comparative, my lord, difficulties? There are only, my lord, 5 persons in the cadre. There are only 5 persons.
Who is the senior most? Who's senior between the two?
Respond number
He's
3.
senior. He's
Respond number 3.
This is a seniority in the entire cadre across the state.
No, that then, my lord, it could have been that, my lord, all the 5 persons could have been considered for a transfer in the public interest, my lord. That is the required, my lord, to be done every 3 years. They do not do it. Now you want to give it a color of, my lord, public interest. On this ground itself, it should go, my lord. That is what the, my lord, Honorable Supreme Court says, my lord. You cannot say the request transfer is a, my lord, public interest. This is my limited submission.
Heard Mr. M.K. Chaudhary, learner senior counsel, assisted by. Yes, anything more to be submitted? Sorry.
What happened? I'm going to return after 1 year, Lordship. Earlier also I have submitted a representation, considering the effect of my ailing mother and son who is studying LLB. So that, and that day, on that year, my prayer was not considered. Now I have, I'm serious, my mother is sick, that's why I have submitted a representation. The last
But your mother is in Nagaon, not in Guwahati.
No, I can
Hmm.
download it, Nagaon is only 2 hours journey. So I have requested the department.
Government servants have
Because I have already
plenty of
served
leave.
7 years Lordship in Dibrugarh and she's serving 13 years in Guwahati. One has to go, she has to go in Sunday.
On what basis? That's what we're asking you. Where is the transfer policy?
That's like posting Lordship, if her representation can be considered, my representation also to be considered. Lordship.
Absolutely.
Uh,
Absolutely.
Then both of the party, if she's, her representation is to be considered, my representation is to be considered.
All right.
With the senior, most official Lordship.
Well, if I receive permission for one sentence, my lord. If my lord, his my lord, representation is considered, my lord, that has to be considered along with the others, my lord, not
It's
only
already
me.
considered an order passed, which is what you are challenging before the
My
court.
lord. No, what I say, my lord, I have been singled out because there is another post in Guwahati.
What post?
My lord, the
Labor court.
in the industrial tribunal.
Huh?
There is another post.
You are in the industrial tribunal or labor court?
Labor. I am the labor court, my lord. He was in the industrial tribunal. In Guwahati, there is another post. Why me? I have been singled out.
That reason is here that you are the only person who have not been in Dibrugarh. That reference is here.
My lord, in the regions that have been recorded, I am not.
You are in Guwahati since 2012.
And the other person in Guwahati, I don't know, my lord. That has not been taken into account.
Heard Mr. M.K. Chaudhary, learned senior counsel, assisted by Mr. N. Dekka, counsel for the petitioner. Mr. D. Bora, learned government advocate, representing the department. M.S. R. Bora, learned counsel, representing respondent number 3. The challenge in the present writ petition is to the transfer order issued by the respondents number 2, by the respondent 1 and 2, by the order dated 2006-2025, by which the petition by which the private respondent number 3 was transferred from his post as registrar, Industrial Tribunal, Dibrugarh, and posted as registrar, Labour Court, Guwahati, with immediate effect. And the petitioner, who was posted as registrar, Labour Court, is transferred and posted as registrar, Industrial Tribunal, Dibrugarh, with immediate effect. Stop. The learned senior counsel before this court has submitted that the impugned order of transfer is challenged only on the ground that it has been given the color of public interest within courts when this transfer is on the basis of the request, personal request made by the private respondent number 3. So, learned senior counsel submits that when a transfer is made on request, it should be a transfer effected on the request of the applicant, and it will not be in the interest of public service, as have been sought to be shown in the impugned order dated so and so. While this matter was moved on
25/6.
on 25/6/2025. This court recorded. This court permitted the government advocate to place the relevant record on the next date fixed, which is 3006/25, with an assurance that no coercive action will be taken against the writ petitioner in the next date of listing. So this interim order stood extended on the next day. So subsequently, when the matter was listed again on 21/7/25, the interim order was expanded to specifically indicate that the transfer order dated 2006/2025 shall not be given effect to till the next date fixed. Stop. This interim order was extended until it stood modified by the order dated 18/9/2025 in an IA filed by the private respondent number 3. So by order dated 18/9/2025, upon submissions before this court that the petitioner, the private respondent, had already joined in his new place of posting, that is River Court, Guwahati. The interim order was modified to the extent directing the status quo to be maintained as regards the post of Registrar, Labour Court, Guwahati, until further orders. Stop. Better. The parties have exchanged the pleadings, the respondents as well as the private respondent dispute the contentions raised by the writ petitioner. Stop. The learned counsel, senior counsel for the petitioner submits before this court that as per instructions, the records in this matter available with the department will reveal that this is not a routine transfer. This impugned transfer order was issued on the basis of an application made by the respondent number 3. Stop. The petitioner has also made a request after the transfer order was issued, giving reasons as to why she ought not to have been transferred out of Guwahati. However, that representation was not complied with. Learned senior counsel has pressed into service a judgment of the Apex Court in Secretary to the Government Department of Health and Family Welfare and another versus KC Devaki, reported in 2025 SCC online SC 639. Stop. Pressing this judgment into service, the learned senior counsel submits that where an order is made at the request of an officer the same does not partake the character of a transfer made in public interest. So he therefore submits that if it is made on the request of an officer, then the corresponding hardships likely to be faced by the petitioner also ought to have been taken into consideration. Stop. He therefore submits that the respondents have considered the hardships faced by the private respondent number 3, overlooking the claims of the petitioner, and therefore the impugned order of transfer, being colorable in nature, ought to be interfered with and set aside by this court. Better. Mr. D. Bora, learned government advocate, submits that this order is indeed an order issued under public interest, inasmuch as for exigencies, for administrative exigencies, transfer being an incidence of service, the officers and personnel of the department under the labor are required to be transferred depending on the administrative requirement of the department. Stop. He further submits that there is no illegality in the order. The records will reveal that the petitioner has continued in Guwahati for about 12 years. And therefore, under in exigencies of service, the transfer order was given effect to, was issued, and the same was given effect to. Referring to the judgment referred by the counsel for the petitioner, he has countered the same by placing reliance on an order passed by the Apex Court in 1991, Supply 2 SCC 659. This is party name is Shilpi Bose versus State of Bihar. Referring to the same order, the Apex Court, he submits that unless transfers are issued contrary to the rules or on grounds of malafide, high courts are ordinarily not required to interfere with transfer orders while exercising judicial review of the same. M.S. R. Bora, learned counsel representing the respondent number 3, also submits that the respondent 3 has earlier filed a representation which was turned down, and now on account of personal hardship, which is reflected in the representation, she had approached this authority, and they have considered the application and passed the impugned order. Stop. While she does not dispute that the application, the impugned order was on the basis of an application by the respondent number 3, she, however, disputes the claim of the petitioner that this order, impugned order, was not issued in public interest. Learned counsel for the parties have been heard. Meetings available on record. I will carefully peruse. Judgments pressed into service have also been carefully noted. Stop. The records pertaining to the leading to the order of transfer has, upon being directed to be placed, are also placed before the court. But having perused the records, it is seen that the initiation of transfer was on the basis of a representation issued, submitted by the private respondent number 3, expressing personal hardship relating to his ailing mother and his child. Stop. His mother, ailing mother, is in Nogam and therefore transferred to Guwahati. Could have been, will necessarily ameliorate his grievances. Stop. The petitioner, on the other hand, pursuant to the issuance of the impugned transfer order, also represented before the authorities, praying for recall of the transfer order. A careful perusal of the records, extract of the records placed before the court, including the note sheets, reflect that the representation of the writ petitioner was examined in detail and was put up for necessary orders by the higher authorities. So, subsequently, the higher authorities approved the order. Stop. It is shown to be digitally signed on 6/6/2025 at 0804 AM by the Additional Chief Secretary. Stop. Subsequent endorsement is that of the concerned minister of the department, which was obtained on 13/6/2025, shown to be signed, digitally signed at 0603 PM. Thereafter, steps were taken to issue the transfer order. And subsequently, on 2006/2025, the transfer order was issued. Stop. A perusal of the note sheets and the accompanying documents available in the extract of the records placed before the court does not reflect any reasons from the authorities to which will support the contention of the respondents that the transfer order was issued in exigencies of service or because of administrative reasons. So, the entire proposal was based on the request made by the writ petitioner, the private respondent 3, which came to be approved and the transfer order was issued. Stop. The records also do not reflect any reference to any specific provisions of the rules or any office memorandum or notification which lays down the parameters of transfer. Stop. On a query made by the court as to the rules which govern the services of the petitioner as well as the private respondent number 3, the counsel at the bar appearing for the parties submitted that there is no specific rule which is in place governing the service conditions of employees like the petitioner and the respondent number 3. Stop. While it is an accepted principle that service is an incidence of service, transfer is an incidence of service, And the employees are required to be transferred depending on the administrative exigencies and the need for efficient administration to be undertaken by the state command. The fact remains that when an application, when a transfer order is effected on the basis of a personal application, the same ought not to have been issued. The same cannot be issued, cannot be stated to have been issued in public interest or in public service. So, reference in this case may be made to the judgment of the apex court rendered in this 2025 SCC online, SC so and so, as also Gita versus so and so, 2025 SCC online, 35. So, the records reveal that the authorities had given sympathetic consideration to the representations made by the private respondent number 3. Stop. However, the impugned order which has been issued as a consequence thereof is an order which is shown to be issued in public service. So there are no reasons available in the records to show as to the administrative reasons or the exigencies which are available or which were available before the competent authorities in issuing the impugned transfer order in public service. Stop. Under such conditions, it is quite clear that the transfer order has been issued. Impugned transfer order has been initiated only on the application made by the respondent number 3. So there is no discussion as to whether the petitioner respondent 3 could have been transferred to Nagaon itself in equivalent posts and only or whether such posts are available, subject to such posts being available. Stop. The records do not reveal that the cases of the petitioner, the respondent number 3, as well as other similarly situated persons have been given due consideration. By the respondent authorities before considering that the impugned order was required to be issued in public service. While no malice personal malice can be attributed to any of the officers. However, malice in law has to be inferred from such actions or inactions if the authorities concerned are found to have acted in a manner which is contrary to established principles of service jurisprudence or the actions taken by the authorities are not supported by adequate reasons, which will appear to be germane, at least, to the actions undertaken. Stop. Under such circumstances, while this court does not dispute with the proposition that service being an incidence of service ordinarily, interference of transfer orders ought not to be encouraged in judicial review, the peculiar facts which have been placed before the court reveal that this transfer order, impugned transfer order, is not the transfer order issued in public service. Stop. Such interpretation cannot be given to a transfer order which is issued or initiated on the basis of a request made by the individual concerned. So, ordinarily, when transfer orders are made on request, then the seniority of the person concerned at the place of posting where the choice is indicated, if such seniority lists are maintained, is would normally be at the bottom of such seniority list. Stop. However, although such is not the case here, the fact remains that the reasons which are placed before the court by the department do not inspire confidence to return a finding that the transfer order was issued in public service. Accordingly, writ petition stands allowed, impugned order dated so and so, stand with the fade with and set aside. Department will pass consequential orders forthwith. Yes, boss.
I'm highly obliged, my lord.
Pending ayes, if any, are also dismissed.
I'm grateful, my lord. There is one correction at one place, my lord. Your lordship says that the petitioner filed the representation and it was considered and allowed. That will be lesson number 3.
I know what petition.
Highly obliged.
Item 6.
Your Lordship, can I get back the records?
Yes. You wait for the order to be corrected.
Yes.
Then
later
you
on.
take it back from the court master.
Yes.
Yes.
Please, your lordship. Lordship is my humble apology to as that I am not fully acquainted with the fact of the case, lordship. I have only come to know that it's a matter of distribution of pension of husbands between his 2 wives. And so as the I does not have file yet, so lordship kindly give me some days to prepare this
Yes,
matter.
what happened? This is not settled in.
Actually, Your Honor, already the respondent number 8 son has informed over telephone that the matter has been settled outside court and the petitioner and the respondent have got all the monetary
He
exchanges.
doesn't have instructions. Then mediation report says none of you appeared.
Yes,
Why you
yes.
did not appear?
Actually, both the parties have not appeared on that day.
No, on subsequent dates.
Then
Many
Your
dates were
Honor,
given.
a date may be fixed so that the petitioner may.
All right, you complete your instructions. Your apology is accepted subject to you giving us an assurance that you will
First
argue the matter
Yes.
on the next date.
Yes, your lordship.
Yes. list on 10th,
Master place.
10th of December. On the request made by council for petition. Yes, yes, 10th.
Item 10.
May it please your lordship. In this case, my case for promotion was not considered, your lordship.
My lord, my friend has filed a affidavit in reply, my lord. He has raised few issues here. I have sent it to the department, my lord, inquiring about few issues, my lord. So that's awaited, my lord. Regarding roster point, my lord, between plains and general categories.
Last occasion you prayed
Yes.
for relying some judgments.
That is there, my lord. But my lord, when I have gone through the, my lord, reply affidavit,
Noted.
those issues, my lord, that has to be, my lord, from the department itself.
We'll keep it for hearing.
Hearing, my lord,
Heard.
hearing. Next week, my lord.
Pleadings complete, issue rule, matter be listed in the month of February. It's for promotion.
Yes.
Promotion, my lord.
When are you retiring?
No,
Many years.
many.
Many years.
Yes, your lordship.
February.
Yes, your lordship. Deeply.
Had delivery or
Obliged.
For hearing item 11.
May I please? Is it last
this
year?
will keep it some other day, Mr.
Lordship.
Islam.
On 11th.
Huh? On 11.
11th.
All right, 11.
Lordship.
Because we have to dictate your order. to the other-
11, 12.
11th.
11.
List again on 11th as agreed to by the council of the party. We'll have it on 11th.
Lordship,
In the meantime,
some instruction we have received, Lordship, regarding the NPS. I may be allowed to file it in affidavit, additional affidavit, Lordship, in the meantime.
You bring it on record in
Lordship.
1 week. you know.
Lordship, Lordship.
This is that sub-register.
Sub-register.
Yes, yes.
Of Lordship.
item 12. May I please before Lordship, my lord, the petitioner hearing praying for her promotion to the post of inspector, my lord.
Lordship, may I pray? On last occasion, actually, Lordship inquired about the status of the case, Lordship, investigation. So as per the last instruction, Lordship, of September, it is stated that this will be filed very shortly, Lordship, either FR or whatever be. So I may be allowed at least 10 days time to get the updated instruction, then Lordship may dispose of the matter.
Yes.
My lord, in this regard, my lord, I rely on one's judgment, my lord.
No, you rely on the judgment, you place it, but
Yes.
first let us get the instructions. What is the status?
Yes, ma'am.
On 12th? No,
Lordship, it can be.
12th
Lordship.
December.
Yes, Lordship.
All right. Matter stands deferred to be listed on 12th December, enabling the learned additional senior government advocate to place before the court the status of the criminal proceedings.
Lordship.
Yes. It's Mr. D.K. Roy for the petitioner.
Obliged, your lord.
Obliged. 13.
Please, your lordships.
Let me, your lord.
Yes.
Before I start, my lord, in this matter, an affidavit has been filed, my lord, affidavit in objection by my lord respondent number 426, my lord. But today this matter has come up for hearing, and the affidavit, my lord, that is only with regard to the maintainability of the present case. So far as, my lord, the affidavit in connection to the writ petitions is concerned, my lord, that has not been filed, my lord, till today.
No, because it's on the point of maintainability.
Only on the point of maintainability, my lord.
There
If they are-
objections as regards the forum.
My lordship. Because, my lord,
According to you, it should be before labor court.
Any other forum, any civil court other than the writ petition court.
Why not the writ?
Because it's not, it's an NGO, it's a private body, it has nothing to do with the government. Government has no pervasive,
But you are performing public duties.
not at all, your lordships.
No.
It's a, no, there is a difference. Public duty But it has to be a state. It has to satisfy the definitions of what constitutes an instrumentality of the state or a state instrumentality or that of. Let me exhibit before your lordships that SOS Children Villages of India has nothing to do with the government other than follow the guidelines that is Juvenile Justice Board or the Women's Welfare Association and things like that. If I may just take your lordships to my short affidavit. And it's one more thing, it's a contract of service. And he has been discharged by invoking a particular clause of that service rules. And there are umpteen number of cases I need not have to exhibit.
I think the law insofar as writ against private has undergone substantial amount.
Exactly, your lordships. That's what I am here before your lordships to prove or establish that it is not the forum before which they can come. If I am able to do that, then comes the question of the merits of the case. Now, your lordships, I am just relying upon, I'm just taking your lordships directly to the judgments of.
So first, tell us about the facts. What
Before that,
I'll just tell you that.
my submissions would be required, my lord, from the petitioner side, my lord.
Right.
So,
So
my
you
lord,
start off.
my lordship.
We'll resume at 2 p.m.
Grateful, your lordships.
Yes, Mr. Kohli.
Yes, Lordship, I'm back on second Lordship. I kept it and in Lordship's order I've mentioned day-to-day required. I was just praying Lordship if today at 3:30 or 3.
Yes.
Because
you
if
can
Lordship
pick it up.
fixes it, it starts and tomorrow then because ours is a vacation of stay. That will not
We
be-
are here until you want us to go.
Lordship, I can't be more grateful than that. But if Lordship may indicate even starting in case it doesn't reach by 3:30, Lordship, at least we'll get going today.
No, these matters essentially the petitioners are questioning that departmental proceedings be kept on hold.
Which have been stayed.
Ah.
And therefore, since December, January, there are two orders. December, January stays the departmental proceeding. So it's 1 year exactly. If on the 6th, it will make 1 year. And on January, there is a reinstatement order. In February, we moved the vacation of stay application. We went to the DB. DB said we had not filed reply. We have come back. So that's not relevant. We are now on vacation of stay. There are 2 points that are coming in the vacation of stay being that a final relief has been given at the interim stage, the reinstatement. Second being that a writ per se is not maintainable even on a departmental proceeding show cause notice because no infraction of right has taken place. So therefore, it's a short matter in terms of the vacation. The substantive issue can be taken up.
No, ordinarily it would be a short matter, except that councils like Mr. Kohli.
And I will have Kian Chaudhary Sahab and Arnab and others. But Lordship may keep it today. I'm praying for it, Lordship, because
I have something to submit.
Yes.
I am led by Mr. Arnab Chaudhary. He was about to come today, but because of some personal difficulty in his family, he couldn't come. He had to cancel his ticket. So if Lordship's convenience, subject to my learned senior friend.
Lordship
Take
may
it up
start today
after
because
vacation.
no, Lordship, I'm pressing for it. The stay can be vacated. They can argue what they want, Lordship, because the state is very badly
When is Mr. Chaudhary available to come?
Lordship, there are other batch of matters, so it doesn't matter. Even if it's not Mr. Chaudhary.
I appear in this set of matters. I'm being led by Mr. Arunab Chaudhary.
Yes.
He has a medical emergency in his family. He just had to cancel his tickets last night.
It is not personal. He's a friend of mine too, Lordship. And Arnab is someone.
It's a genuine request, my lord. So therefore, I'm making this request.
Let me start, Lordship. At least our recording will come.
What is the purpose of making a genuine request if you are entitled to start?
Lordship, Lordship, I'm on vacation.
If they relent, we have no problems.
Lordship.
But in the face of a personal.
But Lordship, I'll just point out there are almost 45 matters, Lordship.
Yes.
Now, Lordship, in that, not all matters, Mr. Chaudhary is there. Arnab Chaudhary. There's also Mr. Kian Chaudhary. There are other councils. And my arguments are identical in all.
We'll come back. You sort it out.
Lordship, will be in your hands. So on 29th. I spoke with him. These are dates that were working for all of us. So, but as I said, ultimately it's your convenience, Lordship.
28, 29.
Yes, Lordship. January.
So 28th is a miscellaneous day.
Lordship. 29, 30.
It will be convenient if 29th and 30th.
That's even better. No problem, Lordship. We are ready. No problem, Lordship. Only thing, as we said, we are repeating what we said last time. There are some contempt petitions coming. They should not press the contempt in the meantime. Because we come every time, then a contempt comes up. We say that the
You ask
vacation.
your counsel to raise these objections before the court concern.
We will,
As and
but
when-
Lordship, it will come before you only, Lordship.
I didn't know.
Yes, it has, Lordship. Recently in the past, it's come, which
Oh,
is why I said, Lordship.
You,
It's Lordship in the order dated 24/11/2025. It came before Lordship.
okay.
So that's why saying that may be recorded, Lordship, that since we are coming every time, at one side we are arguing the vacation of stay. Then at the other side, if they move contempt, it becomes a little bit incongruous for them.
Whoever is appearing for the respondents in this contempt should point out that these matters are fixed for hearing in the month of January.
Lordship may just record that much is enough also.
Record what?
That I have pressed for Lordship, that it is already there, Lordship, in the 7/4/24 order, 25 order. Exactly, this is only mentioned, Lordship, in the 7/4/25 order, that taking note of the submission of Mr. Kohli, that contempt petitions are pending, he is given liberty to suitably mention the matters as and when they are listed. So this is there.
My lords, it may be considered on the next date, when Mr. Chaudhary is present, my lords.
Look, they are pressing it today.
Considered what?
That interlocutory application which we
Naturally,
have
everything
filed.
is listed
Yes, sir.
before.
Lord.
There is an interlocutory set of interlocutory filed by the petitioner
Petitioners also.
and one by the state, vacating stay.
I'm grateful.
So, what is the stage of the criminal proceeding now?
That's proceeding, Lordship.
What stage?
Charges have been framed, saying the cognizance was taken, some were added, and
Trial-
witnesses are
trial
being
itself
examined.
is proceeding.
Witnesses are being examined.
All right.
Charges are yet to be framed.
One of the counsel appearing petitioner, Mr. Chaudhary, assisted by Mr. Roy, is unable to appear because of medical emergencies which arose in his medical emergencies. Therefore, the prayer for adjournment is sought for in these matters. You give the list of
Yes, Lord.
the items.
Barring item 38,
Yeah.
category A. I'll give the list.
Considering that all these matters are connected, and the issues raised are similar. We are constrained to adjourn this matter as an adjournment is sought for on personal grounds. Mr. Kohli, additional AD,
Your senior advocate, Lordship.
senior advocate,
Actually, I'm no longer additional agent.
I'm sorry,
I just thought I'll update.
senior advocate appearing for the state. Does not object to the prayers made as the same are made on personal grounds. Is that okay? Or we say that you objected and then
Lordship may just leave that at what Lordship said first, as you understand how it is, Lordship.
has agreed to that all these matters, including the IAs, be listed on 29th of January.
Interim orders.
Interim orders passed earlier.
29th, 30th, would Lordship?
Will continue. An endeavor will be made to continue the hearing. If it does not conclude on 29th, on the succeeding day.
I'm so deeply grateful, Lordship.
List accordingly.
Grateful.
May it please your lordship, a small query. Item number 4, your lordship has fixed the matter on Thursday, your lordship. Lordship, I kindly request the matter may be taken up on coming Tuesday.
So let it be on Thursday. You renew your prayer. We'll see what happens. Let it come on Thursday first. All right? Yes. We have signed the order. That's the whole problem. Yes.
Item 13.
Yes.
Wait, please, your lordship.
People are Just a minute.
My lordship.
Yes.
Matter, my lord, it also have come up for orders because they have sought, my lord, liberty to file affidavit once it is, my lord, if this prayer, their prayer gets rejected. But anyways, my lord, so far as the plea of maintainability is concerned, my lord, that may I take your lordship to page 46, my lord. It's an organization, my lord. Basically, my lord, the factual background of the case is that, my lord, I work as a senior co-worker in the organization respondent, my lord. And, my lord, without following due procedure, I was, my lord, terminated from service. The functions of the organization and the functions that I perform in the organization are purely, my lord, public in nature because the organization deals with, my lord, unprivileged children, my lord. And that is, my lord, my duty was to look after those children, my lord, who were assigned to me, my lord, in their day-to-day welfare of, my lord. So before that, my lordship may kindly come to page number 46 of my writ petition. 46, my lord. This is, my lord, the certificate, my lord, issued to the SOS Village Organization, my lord, by State Child Protection Society, Assam, Government of Assam Organization, under JJ Act, my lord. And herein it is stated, my lord, the institution shall remain bound to follow the Juvenile Justice Care and Protection Act 2015, the Juvenile Justice Care and Protection of Children, and, my lord, regulations framed by the central oblique state government from time to time. So the functions that SOS Village performs has been guided by, my lord, either the regulations of the central or the state government from time to time, or directly by the committee constituted under Juvenile Justice Act, my lord. Now, my lord, page number 48. This is, my lord, grant in aid, my lord. Public fund, my lord. May I read, my lord? In pursuance of the sanction order issued by Government of Assam, Social Welfare Department, dispute, white sanction letter number so-and-so dated so-and-so, sanction is hereby accorded for grant in aid to 32 NGO-run children homes as first installment for the financial year 2022-2023 for an amount of rupees 3 crore 26 lakhs only, may be released as allocated through PFMS to the respective districts. Now, my lord, page 49. The concerned organization is at serial number 24, my lord. SOS Children Village of India.
And what is 23?
23, my lord, this is Guwahati, my lord. So,
different organization.
My lord, different organization.
Okay.
Now, my lord, page 30. It is their memorandum of association, my lord, under which the organization functions, my lord. Article 3, my lord, the objects for which the society is formed are as follows. And on the last line of that para, my lord, it is specified operating exclusively in the public interest. And last para, my lord, interact and cooperate with government and non-government agencies in administration and organization of schemes and funds in furtherance of the child care work. Now, my lord, page 31 of the Memorandum of Association, my lord, last para, point number 12, my lord.
No, in page 30.
31, my lord.
30, you refer to which point?
30, I refer to, my lord, the Article 3, the objects for which the society is formed, my lord, that first para, that exclusively in public interest, and then last para, my lord. last para. Then page
Yes.
page 31, my lord.
Yes.
Last para, my lord. Serial number 12. To adopt, carry out, or give effect to agreements between the society and any government authority, central, state, municipal, local or otherwise, company, whether the incorporated in India or outside India, firm or person or society for the objects of the society and oblique or in respect of any matter concerning the affairs and of the society, my lord. So this is in their memorandum of association, my lord. The clauses, my lord, clearly specifies that, my lord, their object is for, my lord, performing public duty. Their interactions are there with the state as well as central agencies, government agencies, and they operate, my lord, to, my lord, engage agreements between the state and the society, my lord. And so far as the materials that I have placed in my writ petition, my lord, but the entire, my lord, the working culture of the organization, it will get clear from the affidavit filed by, my lord, the respondent side, because they are saying that they are not conducting any public duty, my lord. That, my lordship, may kindly come to page number 170 of, my lord, the
170.
170, my lord. That is, my lord, the affidavit filed by the respondent 426, my lord. May I read, my lord? My lord, it gives voluntary services for the betterment of underprivileged children of the country. SOS Children Villages of India. The respondent number 4 is a society registered under the Societies Registration Act 1860 and is a reputed social organization in the field of child care. In addition to several projects, the two flagship programs that form the core of the respondent number 4 organization are: number 1, Family Like Care is a curative program of SOS Children's Village India that reaches out to over 6,500 children through its 31 children villages across India. Each village has family homes, with every home consisting of 8 children on average, along with an SOS mother. Holistic development, including education, nutrition, health, and psychological development, is taken care of until children are settled in their lives. In addition to the children's villages that form the core of SOS Children's Villages of India's work, the organization runs a whole gamut of program and facilities in support of socially disadvantaged and impoverished families to help them lead a decent life in the long term. Para 171, my lord. Page 171, my lord. I'm sorry.
Yes.
Family Strengthening Program, FSP for short, is a preventive community intervention program through which over 38,000 children have been impacted over 83,000 lives. Designed to prevent children from losing parental care or being abandoned, this program runs in slums and rural areas within a 30-kilometer radius of an SOS Children's Village. The beneficiaries of this program are children of the most vulnerable families, children of widows, single women, and below poverty line families, as well as families whose livelihood have been impacted by disaster. Spanning from 3 to 5 years, the program aims to enable families to move out of the vicious cycle of poverty towards greater dignity and self-reliance by ensuring children's education and income generating capacity development of the caregivers. The respondents are not financially, functionally, and administratively dominated by or under the control of the government in any manner. This is wrong, my lord. It is, however, submitted that the respondent number 4 SOS CBI is bound by the direction as and when issued by the Department of WCD and Juvenile Justice Act, my lord, that they have admitted. So what I'm trying to postulate from this, my lord, paragraphs, my lord, that, my lord, the SOS Children Village, my lord, is rather, my lord, conducting a public service, my lord. And, my lord, my job is to look after the children, my lord, who were allotted under my care. And my duty was also, my lord, public in nature, my lord. Now, my lord, as I have already pointed out, my lord, page 177, my lord. A wrong averment has been made, my lord. First para, second para, my lord. As already submitted herein above, respondent number 4 is sustaining itself from the funds raised from the general public and without any financial contribution of the government. But rather, my lord, this organization is apparently funded by the government. My salary is being drawn by the funds, my lord, that has come from the government, my lord. And that, my lordship, has already perused in the annexure I have submitted in my my lord writ petition.
Yes.
Apart from that, my lord,
Yes. Yes.
I have filed a rejoinder, my lord, wherein I have submitted some documents that I have, my lord, received by way of RTI applications that has been done, my lord. Page 263, my lord. Rejoinder that has that I filed, my lord.
Yes.
My lord, 263, the question and reply, my lord. There is one table, my lord. Could you please provide me with detailed information regarding the NGO's SOS Children Villages, whether the CCI SOS Children's Village have received any grant from SCPC Delhi, WCD Delhi? The reply is yes, my lord. And my lord, payment that they have received, my lord, you will find at page 265, my lord. These are, my lord, grant in aids, my lord, from the government. As it is a pan-India organization, my lord, that is why I have annexed this document, though it has been provided to me by my lord Delhi authorities, my lord.
Yes, sir.
Then page 267, my lord, another grant received, my lord. It has been provided to me, my lord, page 266. This is from Shillong, my lord. Research Officer, Public Information Officer, Director of Social Welfare, Meghalaya, Shillong. Page 266. 267 is the grant received for the financial year 2021 to 2022. Then, my lord, the office wherein I was lastly performing my duties, my lord, the land has been, my lord, given by the government. Page 268, my lord. Third point, my lord. Page 268. Third point, my lord. 25 bighas of land received as donation. The order was delivered under SDO Civil LSE 1986, 9 January. Now, my lord, page 270. At the time of, my lord, the present petition, whether the organization was functioning or was registered under the, my lord, Juvenile Justice Act, page 270, my lord. It is the renewal certificate issued by, my lord, Secretary, Social Welfare Department, Assam, come Member Secretary, State Child Protection Society, Assam, my lord. After perusal of the documents submitted as per Form 27, Rule 21, the registration of SOS Children Village, Hojai, adjacent HMM Hospital Main Road, POPS Hojai District so-and-so, under Section 41(1) of the Juvenile Justice Care and Protection of Children Act 2015 is renewed up to 10/4/2024 for a period of 5 years. Now this is important, my lord. The institution shall remain bound to follow the Juvenile Justice Care and Protection of Children Act 2015, the Juvenile Justice Care and Protection of Children Rules 2016, and regulations framed by the central state government from time to time, my lord. Other documents I have annexed, my lord. These are, my lord, all, my lord, land related documents, my lord, that has been allotted, my lord, to SOS Village, Hojai. Now, my lord, 2 judgments. Did I, sorry. Yes, a copy, extra copy আছে তেওঁক দিবলৈ 2015
Judgments.
yes yes
Ergo.
2015 to GLP 337
Ergo, what
Sorry.
is the case name?
uh, Abdul Ghafoor Mondal. My lord,
Mr. Counsel.
copy এটা দিয়া है। My lord, this is the judgment passed by our High Court, my lord. Herein, because my lord, the reply that has been filed by the respondent side, my lord, 4 to 6, my lord. Other respondents have not replied, my lord. 4 to 6, my lord, their claim is only limited to the extent of whether this particular case is maintainable or not on the basis of, my lord, that they are a private institution, my lord. But the challenges that I have raised in this particular case is still remain unanswered, and they are seeking a liberty. And for that, my lord, considering this order, which specifies that, my lord, facts and circumstances of the case has to be taken into consideration. The stand of
Yes.
the stand of the respondent side with regard to the factual aspect of this particular case is still it is yet to come, my lord. Only para 26, my lord.
Yes, yes.
My lord, para 26, my lord, of the
Full
Abdul
bench.
Ghafoor Mondal, my lord, division bench judgment of our High Court, my lord.
Para 26.
26, my lord.
Yes,
Married, my lord.
yes.
A consideration of the aforesaid judgment of the apex court goes to show that the term authority used in Article 226 has received a more liberal meaning than Article 12. Under Article 226 of the Constitution of India, high courts can issue writs for enforcement of fundamental rights as well as legal rights. The expression any person or authority used in Article 226 is not confined only to statutory authorities and instrumentalities of the state. The remedy under Article 226 of the Constitution is preeminently a public law remedy and is not generally available as a remedy against private wrongs. While form and identity of the body is not very relevant, the nature of the duties cast on the body is of prime importance. If a private body is discharging a public function and the denial of any right is in connection with the public duty imposed on such body, the public law remedy can be enforced. Even a purely private body over the internal affairs of which the state has no control would also be amenable to jurisdiction under Article 226 of the Constitution of India, provided such body is performing public functions. Thus, the expression any person or authority used in Article 226 can cover any other person or body performing public duty, and the High Court can issue prerogative writs to wipe out injustice whenever it is found. Para 27, my lord. In view of the position of law as enunciated by the apex court, we are of the considered opinion that the question placed before the full bench as to whether a writ petition will be maintainable against a purely private managed institution such as ventures, schools, and also the question formulated by us as to whether a writ petition will be maintainable against non-government education institution as defined in section 2G are not capable of being answered either in the affirmative as emphatically held in Anupam Sinha or in the negative as unequivocally held in Muhammad Ali Haider Supra. The focal point in both the aforesaid decisions was the body or the form instead of nature of duties or functions in which such private body discharged or failed to discharge leading to filing of the writ petition. We hold that maintainability of a writ petition under Article 226 of the Constitution of India will have to be determined not with reference to the body or the form. In case a private institution or a private body or an individual, the foremost question that has to be posed is whether the grievances expressed related to discharge of public function and denial of any right in connection with public duty imposed on such body. Necessarily, the determination as to whether writ petition will be maintainable in a given case in case of a private body or institution will have to be judged on the basis of facts and circumstances of the case in the light of the principles laid down by the apex court. As discussed herein above, there cannot be any straitjacket formula of universal application. Then, my lord, page para 46, page 12, my lord. My lord, it must also be remembered that the remedy by way of writ petition cannot be relegated to an ordinary or regular remedy. It is an extraordinary constitutional remedy, and it is within the discretion of the constitutional court whether to invoke res jurisdiction or not, my lord. Then, my lord, another judgment, my lord, 2020-14 SSC 449, my lord. Marwari Balika Vidyalaya versus Asa Srivastava and others. My lordship, may kindly come to para 15. This is judgment, my lord. May I read?
Yes, yes.
Writ applications was clearly maintainable in view of aforesaid discussions and more so in view of the decision of this court in Ramesh Ahluwalia versus State of Punjab, in which this court has considered the issue at length and has thus observed. In the aforesaid case, this court was also considering a situation where the services of a lecturer had been terminated who was working in the college run by Andi Mukti Sadguru Sri Muktaji Vandas Swami, Suvarna J. Anti Mahotsav Samarak Trust. In those circumstances, this court has clearly observed as under. The term authority used in Article 226 in the context must receive a liberal meaning, unlike the term in Article 12. Article 12 is relevant only for the purpose of enforcement of fundamental rights under Article 32. Article 226 confers power on the High Courts to issue writs for enforcement of fundamental rights as well as non-fundamental rights. The words any person or authority used in Article 226 are therefore not to be confined only to statutory authorities and instrumentalities of the state. They may cover any other person or body performing public duty. The form of the body concerned is not very much relevant. What is relevant is the nature of the duty imposed on the body. The duty must be judged in the light of positive obligation owned by the person or authority to the affected party. No matter by what means the duty is imposed, if a positive obligation exists, mandamus cannot be denied. Here again, we may point out that mandamus cannot be denied on the ground that the duty to be enforced is not imposed by the statute. Commenting on the development of this law, Professor D. Smith states, to be enforceable by mandamus, a public duty does not necessarily have to be one imposed by statute. It may be sufficient for the duty to have been imposed by charter, common law, customs, or even contract. We share this view. The judicial control over the fast expanding maze of bodies affecting the rights of the people should not be put into watertight compartment. It should remain flexible to meet the requirements of variable circumstances. Mandamus is a very wide remedy which must be easily available to reach injustice whenever it is found. Technicalities should not come in the way of granting that relief under Article 226. We therefore reject the contention urged for the appellant on the maintainability of the writ petition. The aforesaid observation have been repeated and reiterated in numerous judgments of this court, including the judgment in Unikrishnan and G Telefilms Limited, brought to our notice by the Learned Counsel for the appellant Mr. Parekh. In view of the law laid down in the aforesaid judgments of this court, the judgment of the learned single judge, as also the division bench of High Court, cannot be sustained on the proposition that the writ petition would not maintainable merely because the respondent institution is a purely unaided private educational institution. The appellant had specifically taken the plea that the respondents perform public functions, that is, providing education to the children in their institutions throughout India. It is apparent from the aforesaid decisions that the writ application is maintainable in such a manner even as against the private unaided educational institution.
Yes.
And my lord, this particular case, my lord, my present writ petition, my lord, I have, my lord, essayed that the SOS Children Village, the functions performed by them are, my lord, public in nature, my lord. It is towards the welfare of the children and, my lord, unprivileged families, my lord. And my duty was to look after the welfare of the children. And, my lord, in spite of that, my lord, without following due procedure of law, my lord, I was terminated from service, my lord. Apart from that, my lord, the entire organization is funded by the government funds and, my lord, under the, my lord, direct control of government. the regulations of central government as well as, my lord, state government. So under that circumstances, my lord, Honorable Court has the ample power to decide this matter under Article 226 of the Constitution of India, my lord. That is my humble submission.
Now, what is on what grounds were you terminated?
My lord, the grounds, my lord, the termination letter, my lord, you will find, that is also very interesting, my lord. Nothing, my lord. Page
No, no,
55
you
of my
were
writ petition.
appointed as what?
I was appointed as, my lord, co-worker. I was initially appointed, my lord, on, my lord, contractual basis. Then, my lord, I was, my lord, confirmed as the senior co-worker on 14/8/2014. I was performing duties since 14/8/2014 to, my lord, 11/1/2024, 11 years of my service. Then, my lord, one fine day, my lord, without showing any, my lord, without issuing any notice, my lord, and, my lord, by violating the rules that service rules framed for the SOS, my lord, society's employees, my lord, they have terminated me, my lord. And the termination letter, my lord, it is specifically clear, my lord, page 55, that they have not, my lord, adhered to the correct proposition of, my lord, how to, my lord, discharge or terminate an employee, my lord. I was not terminated on the basis of any, my lord, allegation upon me, my lord, that I was not performing my duties diligently. I have put 11 years of my service, my lord. And then one fine day, they have terminated me just like that, my lord. Page 55 for a moment, if my lordship peruse my termination letter. Without any reason, my lord. Page 55, may I read, my lord? Dear Mr. Somnath Dey, this is with reference to your letter of appointment dated 25/13 as management trainee in SOS Children Village of India and your subsequent confirmation as senior co-worker white communication letter dated July 14, 2014 issued to you in this regard. As communicated in the above referred letters, the terms and conditions of your employment will be governed by the rules and regulations of service for co-workers of SOS Children's Village of India as amended from time to time, in addition to any other terms specified in your appointment letter. The management is invoking clause 31 subclause 2 of rules and regulations of service for co-workers of, quote unquote, my lord, SOS Children's Village of India Human Resource Policy Manual version 4, updated January 18, which mentions that the organization may discharge a co-worker after giving 1 month notice period or payment of wage in lieu thereof, my lord. Subsequently, my lord, in view of the aforesaid clause, the management has decided to discharge you from the employment of the organization with immediate effect.
Is there any contract? Is there any agreements, terms of service?
I have, my lord, terms of service, but in this writ petition, I could not supply all my details because, my lord, my lord, the access to the computer was denied, my lord. It was stopped abruptly, my lord. And, my lord, in this subsequent para, my lord, in view of the aforesaid clause, the management has decided to discharge you from the employment of the organization with immediate effect, and you will be paid 1 month basic salary in lieu of your notice dated. Earlier clause, my lord, it says serve a notice or pay 1 month salary and then you discharge him from service. Subsequently, they themselves has categorically said that you will be paid 1 month salary in lieu of notice, my lord. And this is termination letter, my lord. This is affecting my career in my other organizations, my lord. If I would have had been informed, my lord, prior hand, that, my lord, they have supported me with some notice that will be terminating you from service, I would have had resigned, my lord. That would have been a different story altogether. But without assigning any reasons, my lord, out of nowhere, when I was diligently performing my duties, my lord, they have abruptly terminated me from service. And this termination letter is now affecting in my service career, my lord. I'm not being able to find any other job also.
No, there are two things.
My
One
lordship.
is maintainability of a rate
That issue I have
against
addressed, my lord.
non-government organization
My lordship,
or an instrumentality.
my lordship,
Even assuming we accept your arguments.
My lordship.
That writ is maintainable.
my lordship.
Question is to examine what? What are we trying to examine?
The
Is it a
impugn
case-
termination letter, my lord.
Is it a case, are you urging a case before the court that there is some default on the part of the organization in implementing or in compliance of some public order, public duty, or maybe some rules, regulations imposed by the government? Or is it a case of termination simpliciter?
Yes, my lord, that is my case, my lord.
Uh,
It is not a case of termination simpliciter.
Right, whatever it may be,
My lord.
is it contrary to any government rules, regulations, policies that you can, the termination could not have been done?
I was,
It's a case which you're trying to project in respect of any other termination. According to you, you ought not to have been terminated without notice. Or it is punitive in nature according to you.
no, my lord, my,
This is what we are required to examine.
yes, my lord, that is correct, my lord.
Now
And
the-
that aspect has not come up before the honorable court because they have not filed any reply so far, my
No,
lord.
no, but you.
Only
before
with
the
regard,
court.
but my lord, my
Before the
case,
court.
that is why at the very inception I was submitting, my lord.
No,
My case is that, my lord,
You are before the court challenging your termination.
yes, my lord, that is correct. And that is why, my lord, I was submitting that, my lord, this termination is, illegality of the termination is one aspect, my lord. Effect of the termination is another aspect, my lord. The,
But you have forums, you have alternative forums, labor court, civil court, so many forums you have.
my lord, the judgment
It's a question.
submitted by the respondent instrumentalities, my lord, recent judgment at teacher's case, my lord. There a teacher was terminated, my lord. And the Honorable Apex Court hold that she was not performing a duty, a clerical job per se, my lord. She was teaching children, my lord, which have public, my lord, importance. And this particular case, I was serving, my lord, our duty towards the society by looking after the welfare of the children, my lord.
That every person employed in every organization is required to do it.
Yes, my lord.
See, the question is, you know the well-settled principles. The writ court will normally not go into areas where there are disputed questions of facts,
My lordship.
right? Now, is it a case that you can project, irrespective of the fact that they have not furnished their reply, that there are no disputed questions of facts? It's everything is apparent that there is complete injustice against you.
My challenge is not limited to this termination letter, my lord. My challenge is with regard to the rule which they have stipulated in the termination letter, my lord.
Let us, where is that again?
Clause 31, page 55, my lord.
55.
But my termination letter itself, my lord, clause 31.
What does clause 31 say?
31 says, my lord, they can at any point of time without giving prior notice or, my lord, by paying 1 month's salary, they can, my lord,
your 1 month salary was paid.
Not paid, my lord. Every, my lord, senior co-worker performing this duty, my lord, will come, my lord, will be affected by Rule 31, my lord. And the more, my lord, this kind of cases, this kind of, my lord, termination letters will come up, it will otherwise affect the welfare of the children and the families per se, my lord. So that aspect, my lord, right now I cannot submit because they have sought a liberty from the honorable court that they'll place, my lord, if their preliminary, my lord, their objection goes. And my lord, I have submitted with regard to my preliminary objection, my lord. That, my lord, I was performing a public duty like the teacher was, my lord, teaching job, my lord, Supreme Court judgment, my lord, that, sorry, yes, sir, down the court.
Well, St. Mary's matter.
My lordship, my lordship, my lordship is correct. So it was an unaided school. But there also honorable court interfered because the teacher was, my lord, unauthorizedly, she was, my lord, terminated from service, my lord. Here, my lord, my role is not only limited to looking after the welfare of the children's, my lord. Under SOS Children's Village, my lord, funded by the government and under the Juvenile Justice Act, the work that I am doing, my lord, will affect the society at large because the families will also get affected, my lord. And if under section rule 31, the similar termination letters will continue to follow, my lord, the balance will, my lord, it will be affected, my lord. No. So at this stage, my lord, let the respondent 4 to 6, my lord, satisfy that it is, my lord, 226 article will not, my lord, cannot be entertained by the honorable court, my lord. Then, my lord, let them say that it is correctly I have been terminated. And let them say, my lord, that no one has been affected, my lord, because of my termination.
Yes.
May I, sir? Lordships, with your kind permission. My learned friend has made certain submissions which are contrary to facts, that it is not, I state at the bar, it is not financed by the government substantially. Secondly, it is not getting into, it is a sort of a public function. I can't say, I can't deny it's not a public function. It's a public function, but at the same time, the pervasive control of the government is not there. It is not going as per the diktats or formulated or formed with the help of a JJ Act. We seek JJ Act's guidance, but it is not totally under JJ Act. Secondly, it's a voluntary organization. There is a vast difference between a voluntary organization, privately funded, and an organization which is formulated as per the statute. I don't have to really make certain submissions. It doesn't even implement government schemes. See, to functions a public duty, it has to also implement the government schemes. Nothing of that sort is done. It is a private body, and it is, he has made certain submissions with regarding to the grants and the land. Now, I'm addressing that first. The land is a donation, and a donation doesn't mean that the government controls it. They have voluntarily donated it with a rider that in the event if my aims and objectives are not implemented, then they have all the powers to withdraw that donation. Number one. Number two is grants. Grants is a reimbursement. I am not the only institution. There are umpteen institutions which are undertaking cases like this. And what I do is they have a set budget for the children's fund or whatever fund they have. I, as an NGO, have to fill in a form saying that I have 50 children on whom I have spent this much of money. Based on that, they don't give me that 50 children's money. What they do is they select. And out of that pro rata basis, it may be even 10, it may be 5, and in certain years it is nil. So this reimbursement, even his document says it's only a reimbursement, a grant reimbursement. A reimbursement cannot be treated as a financially aided organization. It comes in handy for certain objectives of mine, but that doesn't mean it is having a total or a, what do you call that, substantially funded word that we use.
See, the judgment you're relying on, that St. Mary's, I think it's relied on by you? No.
I don't.
Yes.
But it's in my first initial write-up, I think, no?
I think some affidavit you have filed, I think it's a part of that.
Short, 19 to 48.
Yes. So that judgment itself lays down the parameters in which,
Lordship may turn to page 50
hmm,
if he is.
50.
No, 150, yes. Last 5 lines of 50. I'm relying only on that. I have highlighted it. I'm relying on that 4 lines.
Hmm.
My copy doesn't, was purely contractual. Probably the contract was purely, a relationship between the parties are purely contractual. A contract of personal service cannot be enforced specifically. Therefore, the respondent number 1 cannot find a cause of action on any breach of law, but only on the breach of the contract. That being so, the appellant's remedy lies elsewhere and in no case the writ is maintainable. This is my highlighted reliance.
You're referring to page number 50.
Page
50.
number 21, bottom you will find a small typed page 21 of the judgment. If your lordship can see at the bottom,
Page number 21.
2-1
Yes.
and 5-0, last 4 lines.
Hmm.
Just above 51, you will see last 4 lines. I am relying upon this. Whatever it is between me and the petitioner, it is a contract of service, a private contract of service. Your lordship, I'm grateful to your lordship for having asked that question to the petitioner as to what is it that he is trying to make a case before your lordships. The case is, he, according to him, it is an illegal termination of services without.
Right. So see, the question which both of you have raised, or rather you have objected, is essentially a question whether the writ is maintainable
Yes,
or not.
I am satisfying your lordship
Now,
on that.
you have raised this issue that you're not a public body, not performing a public function, no governmental control.
Not at all.
No writ is maintainable. Again,
Absolutely, your lordship.
right? But the analysis of the judgments which have come today, there is no definite parameter to decide whether a writ is maintainable or not.
Ajay Hasia has not yet been overruled, your lordship. So with utmost respect, I have to say,
Subsequent judgments.
yes, but
Subsequent
not
judgments.
overruling. That is what
No.
my submission is.
No. Overruled or not is a different issue. But the question is, are we to ignore the subsequent judgments because the earlier judgment has not been specifically overruled?
The subsequent judgment says, if I am functioning a job or an act,
No. So you kindly wait for the court to formulate you the query.
please.
See, the projection before this court is that the writ petition is not maintainable because you're not a public body, you're not a state, you're not under public finance. But perhaps the question should be, even if a writ is maintainable, whether in the facts of the circumstances of this case which are being urged, which according to you is purely a contract of service, whether a writ is maintainable.
Grateful, your lordships.
Right?
That is exactly what my contention
So
is.
if that is your contention,
Yes.
then besides objecting to the maintainability of the writ, you are required to bring on record to show how the contract of service between the petitioner and the respondent
His own
was
document
initiated.
is here. His document is here.
No, but you did not bring it on record.
No, I haven't come because I'm confident. Probably I'm overjudging myself, but I'm confident that writ is not maintainable before.
You are entitled to have your view, but the
No,
question
thereby.
would be to decide.
Yes, I
whether-
need to file a proper answer to the other issues that he has raised.
So that
I'm-
we decide whether in a particular case, whether we should invoke our powers. Firstly, prima facie from whatever you have urged before the court, you admit that there is some public duty, right? So therefore, on the face of it, one cannot really say that you are an absolutely private organization without any public duty. Therefore, there's no question of a writ being maintainable. This is what. The other is, even if you're performing a public duty, whether the issues which are the list which has been placed before the court at the behest of the petitioner, does it require a writ court
To decide it.
Decide it and enter upon this. Now, for us to decide that, there must be materials placed by both parties.
I think I can invoke my liberty on that now.
Yeah.
Because you want the entire gambit to be presented before the. I mean, it.
This is what the law says.
Law say, okay,
This is what
I
the law
stand
says.
corrected. I stand corrected. What I would like to do is give a entire, instead of a short affidavit, file a detailed affidavit. Or what do you call that, a reply, a written statement or what, a counter affidavit, I will call it.
You have already filed an affidavit
Short.
Raising the questions of maintainability.
Now
You are entitled to file
Fact,
still
on facts.
giving a reply to all the queries or all the allegations made in the.
And whatever submissions has been made, I think I can cover that also.
Right. The affidavit questioning the maintainability would also remain on record,
I will be part of that.
part of that. So therefore, because if you come to para 70, I think 75, if I'm not wrong,
Of,
the Saint Mary judgment. Yes, 75. These are the conclusions of the, which are summed up in the judgment.
no, there are just 72 paragraphs.
I'm referring to SEC.
Oh, okay, okay.
Perhaps. The conclusion part essentially.
In view of the aforesaid, this appeal succeeds and it's hereby allowed impugned judgment and order passed by the DB.
No, before that, that would be para 77 in our, then maybe 1, 2, 4, 5 paragraphs about that.
Lordship, if you can just assist me in reading out the first line.
We may sum up the final conclusion.
Okay. I got 68 according to my. 220, point C, your lordship, of this very paragraph. It must be consequently held that while a body may be discharging a public function or performing a public duty, and thus its actions becoming amenable to a judicial review by a constitutional courts, its employees would not have the right to invoke the powers of the High Court conferred by 226 in respect of matter relating to services where they are not governed or controlled by the statutory provisions.
That's
So
precisely,
this is my case exactly.
that's precisely what we want to decide.
Yes.
Instead of deciding it in part piecemeal, that a writ is maintainable or not maintainable, we may like to
I
say.
may be granted the liberty to
Right.
file a detailed reply, your lordship. So I think that would more or less sum up the case of both the parties.
And this case, my lord, the respondent, private respondent is, my lord, an unaided government school. And here in this particular.
No, not on that.
My lord,
You see,
I'm just
even the
pointing out.
judgments that you're referring to, including the full bench judgment in Abdul Ghaffar.
Yes, my lord.
Is very candid that there is no fixed definition.
Yes, my lord.
So it has to be decided on
And my
the
lord, facts.
functions which are undertaken by the authority. So the functions undertaken by the authority appear to be in public duty as far as the court is concerned.
My lord.
Prima facie.
My lord.
But notwithstanding that, whether your grievance is required to be decided by the court.
My lord.
We
That-
have to
for
decide
that,
it
my
on the
lord.
basis of what materials are placed by the respondents.
My lord.
So you file your detailed affidavit if you want to, and
I'll file, your lordships. Give me about, I think probably in January I'll be filing it
all right.
when the court reopens.
Heard this, Mr. M.K. Das, learned counsel for the petitioner.
My lord.
And your MS Iyer.
KIA.
KIA. Learned counsel appearing for all the respondents.
4 to 6 minutes. Right? Yeah.
I'm 4 to 6.
4 to 6.
The government counsel is also here. He's not filed, but he's here.
Are the necessary parties here?
My lord.
He has made them
Yes.
necessary parties.
Yes, my lord, because it's a public money, my lord.
You are not sure whether it is a public duty, therefore you want to rope in the government.
No, my lord, the public money, my lord, that is
So
categorically.
you are not
accepted.
concerned with public money.
No, my lord,
It's
because.
not a case that public money is being misused.
Because I have to answer to the organization, the organization has answered to the.
Mr. PKS Barua, IPS for respondents 1, 2, and 3. the respondents 4, 5, and 6 has filed an affidavit objecting to the maintainability of the writ petition in view of the fact that the writ, in view of the fact that the respondent 4, 5, and 6 is not a state within the definition of Article 12, nor are they using any government funding. Therefore, on that question, on that point itself, the writ petition ought not to be entertained. So they have therefore filed an affidavit questioning the maintainability of the writ petition. On that point. So, however, to decide on this question, this court is of the view that in view of the catena of judgments rendered by the apex court as well as by different courts in the island across the country, including this court, there is no specific parameters to decide the nature of matters which can or cannot be entertained by writ court in exercise of its powers under judicial review when the writ is sought to be issued against a non-government organization like the respondents 4, 5, and 6. Stop. Recent judgments of the apex court have expanded the scope of the definition. However, the fact remains that even if this court ultimately comes to hold, even if assuming this court ultimately comes to hold that the writ is maintainable, from a question it would be whether the prayers made in the writ petition by the petitioner seeking interference of the termination orders issued by respondents 4, 5, and 6 would ultimately be interfered with are matters of facts and which can be decided only upon a proper detailed counter affidavit that may be filed by the respondents 4, 5, and 6. Stop there. Learned counsel for respondents 4, 5,
6 weeks' time, Your Lordship.
6, therefore prays for 6 weeks' time to file necessary counter affidavit in response to the contentions raised in the writ petition. Prayer made is allowed. List this matter again. We'll have it in February 1st.
Anytime, Your Lordships.
1st of February.
My lordship.
1st of February.
My lordship.
Second, Your Lordship. First is a Sunday, probably.
Is it?
I think so. My diary tells me so.
Oh, you're right. 2nd of February.
My lord, only, my lord, my access to the documents that in their position is now completely prohibited. Only if liberty is granted, my lord,
Let
so
the
that they
affidavit
can,
be filed.
if I approach them,
No, let the affidavit be filed and see what comes.
my lord, let's set up.
Let the affidavit be filed.
Yes, my lord. Obligation.
Grateful, Your Lordships.
I just copy the 16.
My lord, in the case, my lord, before starting my learned friend, my lord, on the last occasion, this honorable court asked the additional AG Dilip Majumdar to address about the status of the case from BTC cadre to general cadre. So may I pray, my lord, the matter may come up after vacation because I'm representing private respondent, my lord. I'm number one,
Where is the additional AG?
My lord, he is on legs before court number 3.
He was here a while ago.
He was here, my lord, matter was called up at court number 3.
What is the issue here?
Issue basically, your lordship, the petitioner herein was appointed in the BTC under the tourism department of BTC as assistant tourism officer. Your lordship. And now what has happened after that, the issue will be with now she is otherwise entitled to the promotion to the next tourism information officer. So for that promotion, the name has to be incorporated in the gradation list. Now what has happened, the PTC has said that since this appointment to the post of transport information, tourist information officer is to be, the approval is required from the APSC. Therefore, the BTC does not have the power to do that. Therefore, they forwarded the matter to the government for incorporating the name of the petitioner in the gradation list of all assistant tourist information officer. Now the government says that since it is the appointment was done by the BTC, therefore they cannot incorporate the name of the petitioner in the gradation list, general gradation list of all the offices under the Assam law. Now my question is, these posts were created by the government of Assam before the BTC. Now the BT, there is no objection that as such that they cannot be promoted or something, but the issue remains that they say you are since you are appointed by the BTC, they will do the needful. And the BTC says that we cannot promote you because this APSC approval is required. So government will. They have forwarded my name for incorporating in the gradation list, but that was not done. And the ground that was taken was very flimsy. I'm not by the government that why they are not incorporating my name. They said that the qualifications required in the appointment in Assam, in the state of Assam is not is different, and that of the BTC is different. But in the case of the BTC, the petitioner's qualification is better than that was required by the state of Assam. Therefore, Your Lordship, that looks very
So
flimsy.
your case is that you belong to one cadre,
Yes,
created originally by the Assam.
Assam government.
After creation of BTC, some posts
No,
were
no,
sent.
no, that is not. Actually, these 7 posts were created under the BTC. When the BTC came into existence, these posts were created by the state government, and they have given that the appointments are to be made by the BTC. So appointments were made by BTC. But what has happened? This promotion part where the petitioner is in grade 3, so it will be to grade 2. But there is a catch here where in the original, when the agreement between the state of Assam and the BTC came into existence, there was one clause where says that the appointments above the grade 3, that is to where APSC approval is required, that will be by the state of Assam. That will be by the here APSC approval is required. Therefore, my name was forwarded from the BTC to the state of Assam to put it in the gradation list, so that as and when the APC approval is required, if the seniority comes into existence, then I'll be selected. But that was not done, saying that now you are a different cadre by the Assam government. When the question arises why you are in a different cadre, because
What does the BTC say about it?
BTC is supporting my case totally, because they say that yes, we have forwarded your name, you are otherwise qualified to be promoted, your name should be incorporated in the gradation list of the general, all the candidates in that cadre. But Assam government says no, we cannot do that because your selection is, you have selected her, we have not selected her. And secondly, the qualification experience required by the state of Assam and BTC is not same. But that is not correct.
Where is the creation of posts? The order, is it available?
That is, it's available. There are actually 2 read petitions. I'm just pointing out. In one read petition, basically we are challenging the first one that we are challenging is that with regard to the gradation list that has been published without the name of the petition. And the first case was with regard to the gradation list, draft gradation list where the petitioner's name was not there. There's a stay order operating not to promote in this post. So that is there. Now here the creation was in, I think at that point, I'm just getting through it. It was there. That is at 17/2/2009. 17/2/2009. I'll just, if it is annexed or not, I'll just.
Yeah, page number.
Second,
That is at page,
it is second line,
uh,
43.
page number 20. Page 34. 35.
35.
35, this is the typed copy. And page, I think 37 is the copy. Page 35, annexure 1. This department, along with the post, were created by the state government in 2009. There are 7 postings. The petitioner is the Assistant Tourist Information Officer. The third one. Now her promotion will be to the post of Tourist Information Officer. But that post is a grade P post.
No, page 35.
Page 35 of WPC 659.
Yes.
Page 35. Annexure 1. 17th February 2009.
You are now in which post?
I am in the post of Assistant Tourist Information Officer. That is at serial number 3.
Yes.
Now, my promotion is in the post for the post of Tourist Information Officer. My case basically is that I am entitled to be put into the gradation list of the state in the state. In fact, there was another case. This is not with regard to tourist, with regard to another department, where there was a case filed by some employees of the education department, where they were ex-cadre, saying that they were not in the cadre of state of Assam. But ultimately, this Honorable Court directed them to be encadred, and they were ultimately encadred, and their promotions and other orders have been passed subsequently. There was a writ appeal also filed. I have annexed the order of the writ appeal also. So it is not that it cannot be done, it can be done. In fact, the petitioner was appointed in 2011, and there is rule says that you require 5 years of experience as assistant tourist officer, as an information officer to be promoted to the next, that is TIO. Now, what has happened? This particular person has already been there for the last 9-10 years. Sorry, more than that. In 2011, Your Lordship. So it is about 14 years.
Where is
14,
the
15.
communication of the government saying that you don't belong to Assam Kedar, you belong to BTC?
That
Affidavit
They
filed by the government.
they have filed the affidavit. In the affidavit.
But there's no order, specific order.
Just a moment. That affidavit will, Lordship will find at page. That is at page 151. By the respondent number 3. Here your Lordship will find at para 4.
569.
Lordship has got para 4. This is by the Deputy Director of Tourism. Lordship will kindly turn to page 152, paragraph 4. I'll just point out what are the reasons they say that. With regard to the statement made in para 2 of the report, the answering department begs to state that as per the BTC Secretariat so notification, the powers and function of the Central Selection Board are mentioned in clause 4 of the aforesaid notification as follows. The selection board shall abide by the Borderland Territorial Council service rules in respect of recruitment of personnel for BTC. Secretariat and such rules now in force in respect of the recruitment of personnel of 40 transport subjects. The answering deponent further begs to state that as per Schedule 11 Rule 10, the Assam Tourism Service Rules so 1992, now Assam Tourism Service Amendment Rules 23, the minimum qualification and experience prescribed for direct recruitment for the post of Assistant Tourism Office Information Officer is as follows. Lordship will see the difference. A degree in arts, science, commerce of a university recognized by the government. The candidate should be capable of expressing himself in English properly and fluently, as he will have to deal with foreigners and tourists from the other states of India. Now your lordship will see what is there. Whereas the required qualification for the post of assistant tourism officer, BTC mentioned in the advertisement published on so and so was one, your lordship, the minimum educational qualification, graduate, arts, science, commerce, exactly the same. Now here your additional, your lordship, requirements are there. Diploma in tourism or hotel management from a UGC recognized university. Proficiency of language in English, Hindi, Assamese and Bodo. Then candidates shall have at least 3 years working experience in corporate sector of tourism hotel management, experience of use of computer and online marketing tourism hotel management. Now your lordship, how can these be anyway less or not equivalent to the degree that is prescribed by the Assam rules? The Assam says you have to have degree in arts, commerce, science, as well as you have to be capable of expressing yourself fluently in English. Here, apart from these two, here is you need a diploma in tourism. You need 3 years experience. You need computer and other experience also. So how it can be said that you do not have the requisite qualification? These part is also not, your lordship, correctly given, your lordship, in the affidavit. So without being encadred according to them in the state cadre, I cannot be promoted. Now the issue is that BTC has written for the promotion. They are not encadering me. The matter remains there, neither here nor here. And because of these issues, this person's for the last, now it is about 14 years in the same post. And in fact, they have issued the gradation list, and in the gradation list, her name has not been incorporated because of these reasons. And since it has not been incorporated, she cannot be promoted because the APSC's approval is required. And until and unless APSC approval is not given, now who will give the APSC, how it will be given? Now, if there is no gradation list, where will she be given the APSC approval? These are the issues which has actually engulfed the whole matter. And if your lordship will see the whole case from the beginning, now there are some office memorandums, some notifications by the government as well as the BTC and all. Now they are, otherwise both are following because BTC is following the more or less the same recruitment procedure as Assam. And the Assam government, while creating the post, gave the authority to the BTC to appoint. Once I am appointed by the BTC as per the rules or as per the rules under BTC or the Assam rules, I'm in that cadre itself, because these posts are created by the government of us. Once you create it, you give it to BTC to appoint me. Now you cannot say, since BTC has appointment, we are not going to encadre. I don't know what kind of a decision has been taken. That is why one judgment, why I propose to show one judgment which has been annexed here, of the division bench I have annexed, main writ petition, this issue came up with regard to the education. Some education personnels who were working under the BTC where
is the judgment?
The judgment annexed.
Annexed to the writ petition.
Yes, writ petition. I'm just giving the judgment, just a minute. That is at page 82. The writ appeal judgment is there, which upheld the single judge order. 82. So there the court directed encadrement. Similarly, it should have been done here. 82 is the judgment. It starts from 83. Here your lordship may go to directly to the third pair. The appellant before the court was working as casual employees in the tourism department and was subsequently appointed as receptionist in the year 91. I'm not on the facts, your lordship. The facts are absolutely different, but the moot question remains the same. However, since the posts were ex-cadre posts having no promotional avenue, the writ appellants along with 3 others filed the writ petition so-and-so before the court praying for the post of receptionist should be encadred, giving them promotional avenue to the post of Assistant Tourist Information Officer. The writ petition was disposed by the single judge on so and so with the following direction. These are the directions. Proceeding on the above basis, since the receptionist by virtue of a long service may have gathered the skill to discharge the duty in tourism department, those amongst them who possess the educational qualification for the post of ATOs may be considered for recruitment to the post of ATIOs, but such appointment cannot be claimed as a matter of right, but is subject to recruitment process and competition on merit with other applicants, including those from the open market. Therefore, when the state undertakes a recruitment exercise for the post of air, the serving receptionist possessing education qualification may offer the candidature, and the state may consider them on merit by granting them as relaxation having regard to their long service and department. It is ordered accordingly. Insofar as receptionist being designated as junior assistant, since reservation is expressed by the learned counsel for few of the petitioners, the state should designate only the willing receptionist, that is junior assistants. Consequently, those receptionists who do not opt for to be junior assistant will forego the right of being considered for promotion, since they voluntarily opt to remain as receptionists by refusing to be encadred as junior assistant under the service rules. In view of the above decision, the process of amendment of service rules for designation and encadrement of the willing receptionist through amendment of the service should be carried out expeditiously and preferably within 6 months from today and June. Consequently, the interim order marches. Now, they came by a writ appeal. These writ appeals were disposed of by this court with the direction that government should encadre the post of receptionist, and a reasonable percentage of the post of receptionist should be considered for promotion to the post of assistant tourist information officer. Here, your lordship, they are the rank below the petition, and they want to be promoted to the post of assistant tourism development officer. Now, here the issue is practically the same, encadrement with the original one. But 20% and 80% has been fixed. Now, in this case, your lordship, it is already fixed that 50% by promotion, 50% by direct recruitment. And in their affidavit also, in paragraph, I'm just pointing out that paragraph, the that your lordship will find at page 165, para 33. They have calculated this post also. Page 165, para 33.
No, but Writ Appellate Court upheld the judgment of the.
Yes, it upheld. Encadrement was given. Therefore, earlier, which they refused to give encadrement, that was given by the Honorable Single Judge.
How is it applicable here?
That is what it is not exactly applicable. That's what I am trying to point out. Not exactly applicable, but what I am trying to point out, they can encadre this post of the petitioner with that of the judge.
It is an ex-cader post. Is it an ex-cader post?
No, they are saying you don't belong to our camp. That is what they were saying from the very beginning. Because they say that we have not appointed you. It is the BTC who has appointed you. So it is your separate cadre. That is what they started saying.
Now, what about BTC? You can't have, you cannot give promotions.
No.
Why?
From grade 3 to gazette post, we are not permitted.
Who permits you?
Lordship, then the.
You are a sixth schedule.
The state will have to, after from gazette post, lordship is the state. Lordship.
Who's for the state?
My lord, before coming to the state, my lord, I like to apprise my lord why government is not considering, my lord. Lordship, kindly have a look, page 193, my lord. File affidavit filed by the government.
Yes.
Their stand has been taken very clearly, my lord. That has not been challenged as on date, my lord.
193.
193, my lord. Annexure 5 to the affidavit filed by the government, my lord. If your lordship permit me, I'll just read out, my lord. Whereas Bhumarani Bargyari, that is the petitioner, my lord, assistant information officer, now assistant tourism development officer, tourist development, Kokrajhar, has submitted a prior petition to the undersigned for in connection with the inclusion of her name in the provisional gradation list. Assistant information officer, now the assistant information tourism development officer, published by gradation number so and so. Whereas her name was not included in the provisional gradation list of the tourist development officer, now the assistant so and so, re-designate, as she falls under ATIO, now is the cadre of the tourism development, Kokrajhar, as appointed by the director comes CSD tourism development. there is a one fraction, my lord. Others, we have been appointed by APSC selection, my lord. Now lordship will see, whereas her petition has been forwarded to the Tourism Development Government of Assam Administrative Department seeking the
Just
necessary.
1 minute, 1 minute. Ask for the- Somebody will not pull the video, pull the video. Yes, please.
Now lordship will see third paragraph, my lord. Tourism Development Government of Assam Administrative Department dispute has submitted their views in the connection of the inclusion of the name of state gradation list by letter number so and so 27 February 24, according to which her name was according to which her name cannot be included in the state gradation list as enumerated in two separate cadre is not permissible. Hence, her name cannot be included in the state gradation list of Assistant Tourism Development Officer now so and so, and with the decision of the petition of the Srimati Bhumarani Bargwari, Assistant Tourism Officer now Assistant Tourism BTC Kokrajhar, in connection with inclusion of her name of the prohibition graduation list of the now Assistant Tourism is disposed of. Meaning thereby, my lord, government did not consider. Then, my lord, they filed a petition. I also filed a petition. And by virtue of the court's order, my lord, that your lordship will see operative part 205, my lord. Operative starts from 206 page, my lord. Second paragraph. How the list was published and my name stands at serial number 1. That your lordship, I'll take up to page 206, operative part of the writ petition filed by them, my lord. I have filed. Under the court's order dated so and so, provided that no promotion process should be initiated for filling up the vacant post of tourism development officer from the assistant tourism officer, it is further provided that the said order, the respondent shall be at liberty to take decision of the petitioner representation dated so and so. Subsequently, the connected IA was filed by the respondent number 9. This is my email. My case is still pending. This court under this order, while taking up the IA as well as the writ petition, directed the respondents to obtain the instruction whether the representation of the petitioner dated 16/3/22 has been disposed of. On the basis of such, Mr. So-and-so has learned senior government advocate for the department produced an instruction which reflects that the name of the petitioner could not be incorporated in the draft gradation list as the petitioner belongs to separate cadre of BTC. However, it is admitted position that the final gradation list has not been published till date. So the process accordingly, Mr. Nath submits that the later should be allowed to publish the gradation list. This court of the view that without publication of the final gradation list, it may be considered said so and so. At this stage, it is provided that the continuing with the interim order passed earlier till the next returnable date, the respondent authorities are given liberty to publish the gradation list. In the meantime, the decision was taken by the department on the decision of the petitioner 16/3 communicated to the petitioner. A copy of the final gradation list also communicated to the petitioner and when published. In the meantime, so and so doing so on the record decision of the respondent authority non-inclusion of the petitioner in the gradation by way of affidavit. There must be, my lord, another affidavit after 18/1/24. After that, my lord, the gradation list was published. My name stands at serial number 1 and name of the writ petitioner was not included because of the reason page 193. Speaking order, my lord. Neither the final gradation list was put under challenge, nor, my lord, the speaking order was put under challenge. Until and unless the entire gradation list is challenged, though, my lord, they may not get the appropriate relief as sought for in the writ petition. Basically, both the writ petition does not have its in legal force, my lord. Court has directed to publish the list, list was published. That list, your lordship will see my affidavit, my lord, which I have filed. So,
Okay, next for us.
my next, the final.
I differ with my learned friend.
Just
The
a minute.
prayer itself says that set aside and cause the impugn final gradation list. Why we have, he's saying we have not signed. The prayer at page 31.
Without
But
making
what is
We,
the
we are, I'm not on that, Your Honor. My
observation?
main question is, I'm not even against him. His promotion is not against him. My only question is that I should also get it to the gradation list so that I come within the zone of consideration for promotion. There were 12 vacant posts, Your Honor. And there were, sorry, 13 vacant posts, including me, mine. That is what I tried to show, Your Lordship, where they have stated in their affidavit saying
That
that
doesn't show.
there are 12 and 1 ST post. Now, this petitioner is a ST person. She's an ST. Therefore, that post, otherwise also she'll be eligible. Your Lordship. That in the affidavit of the government at page 165, I pointed out, Your Lordship, they have stated that.
This IA is disposed of.
I, my lord, did not, no final order has been passed, my lord, as I have shown your lordship. Lordship will see, my lord, page number. Demand number 2.
Now the decision of the government is assailed here,
Yes, yes.
that you belong to a different cadre.
Yes, obviously.
No, my lord,
Obvious-
that is not put under challenge the page 91, 93. Lordship kindly have a look there, prior portion.
I'm sorry, I was informed, but 3 matter was going.
Now we are informed.
Man,
So why have you made them ex-cadre?
it's not a question of making an ex-cadre, it's totally different cadre, man. There are some transfer subjects there, and some posts have been created for them. And the procedure for appointment qualification.
You are saying that in all or any of these posts created for BTC,
My lord,
no recruitment from or no transfer from state of Assam.
no,
It's only for BTC,
Yes,
within
my lord.
BTC.
and the procedure for appointment qualification is different for them. It is different here.
The
In
qualification
the-
is.
In the affidavit, my lord, we have indicated everything.
uh,
So if you kindly take up the affidavit.
Now, Mr. Manan, just
Not-
1 minute. You are assistant tourism officer.
Yes.
Now, in the tourism information officer, you are seeking promotion to tourism information
Yes,
officer.
I am the assistant tourism information. I am
So
seeking
in
promotion.
BTC, there is no vacancy.
No, there is a vacancy. There is a vacancy in BTC.
There is a
The
vacancy.
BTC is saying that we want to promote her. But for that reason, the approval of APSC is required because as per what my learned friend said.
This is
There-
under the rules. It's required under the rules.
Yes,
What rules?
the rules, that is the OM, there is an OM of 2004 where it has stated.
Where is that OM?
That OM is at page 59. Page 59, the OM starts from page 58.
Yes.
Lordship will kindly turn to page 59. Page 59 and page 60. The page 60, the last part. However, the post where recruitment is being made on recommendation APSC shall not be covered under this provision. So, for recommendation from APSC, this BTC does not have the power.
No, no,
So that is where I got stuck.
no, what is the effect of this OM? This OM is meant for what?
This OM is, Your Lordship, with regard to the settlement between the government of India and the BLT,
Okay.
which ultimately brought in the BTC under the 6th schedule. So that memorandum is basically on that with regard to the constitution of the 6th schedule of BTC. The 6th schedule, they have the power to appoint, but where APSC's approval is required, they don't have the power. So they have written to the APSC, but
No, but where is it provided that APSC's approval is required? Under what under what rules?
no, they have stated it in page 59. H.
So we have seen
59
that
H.
59H is that they will have all powers to make appointment to all posts.
Yes,
This is not.
Following the
not
rules of
changed.
appointment prescribed by Government of Assam.
yes,
Except those posts where APSC recommendation is required.
yes.
Now, where is the promotion to the next high grade? Where is it provided APSC recommendation is required?
Yes, there is a.
Totally different.
That is at, I think this is the notification. Just a moment. There's another notification. That I think this is 2009. Just a
Final
moment.
gradation list without making the party. Party normally to be issued by the commanding the respondent. Second, we say. Final gradation list. It has changed first.
Just a moment, boss. I think it is.
The stand taken by the government in the speaking order is not under change.
No, no. Where is your stand? Where is that?
Page 193.
Speaking.
Page 193 of WPC Mallet 659 lottery C.
Yes.
Speaking order, whereas Srimati, page 193 Mallet.
193.
93.
Yes.
Whereas Srimati Umarani Bargayari, Assistant Tourism Information Officer, now Assistant Tourism Development Officer, Tourism Department, BTC Kokrajhar, had submitted a prayer petition to the undersigned in connection with the inclusion of her name in the provisional state gradation list of Assistant Tourism Information Officer, now Assistant Tourism Development Officer, published by Office Order number so-and-so dated 9th of March 2022. Whereas her name was not included in the state provisional state gradation list of Assistant Tourism Information Officer. As she falls under the ATIO, now ATDO cadre of Tourism Department, BTC Kokrajhar, as appointed by the Director cum CHD Tourism, Professor kindly see, here is one major difference. Whereas, next paragraph, whereas her said petition has been forwarded to the Tourism Department, Government of Assam, Administrative Department Discourse, seeking necessary instruction regarding the inclusion of her name in the state gradation list of Assistant Tourist Information Officer by this office letter number so-and-so dated 1st of June 2022. Whereas Tourism Department, Government of Assam, Administrative Department Dispur has submitted their views in connection with the inclusion of her name in the state gradation list by number so-and-so dated 27th of February 2024, according to which her name cannot be included in the state gradation list as amalgamation of two separate cadres is not permissible. Hence, her name cannot be included in the state gradation list of Assistant Tourism Information Officer. And with this decision, the petitioner Srimati so-and-so dated 16/3/2022 in connection with the inclusion of her name in the provisional state gradation list of Assistant Tourism Information Officer is disposed of. This has to be challenged in my house.
This is not under challenge, Mr. Manan.
No, this is a part of the whole challenge, you know. I think it is.
Prayer, it is not there.
This is the hurdle.
This is an order passed on the basis of the decision with regard to the final decision of the production, for the publication of the main gradation list. The gradation list is challenged altogether on the basis of that. And even I think that order that has been given, my learned friend has shown, that is a, that doesn't specifically, your lordship.
In the first petition, there was a direction on 7th of December 2023.
No, they have categorically held your name cannot be included in the state gradation list.
They stated, your lordship.
Madam, this decision, this speaking order was passed pursuant to a direction issued by your lordship in the first petition.
That was the first. Second, your lead petition came when this was published, your lordship. And then we have come up on that. On the basis of that, they came up by finalizing and publishing the final gradation.
But this particular order clearly says that your name cannot be included for whatever reason. Their reason is that
two different camps.
Two different
camps. That is the challenge, because
but that is not challenged in this petition.
No, that specifically that order is not challenged. Specifically, it has not been challenged. And one more thing, your lordship, that with regard to whether the appointing authority promotion cannot be granted, that is at page 50. That APSC is required, that your lordship is
50
in the writ petition. In the second paragraph, they stated, as the matter is out of BTC competent for promoting grade 3 to Gazette post. The undersigned is pleased to forward the name of so and so along with the relevant documents for inclusion of state registration list and request you to look into the matter first. So they have stated that it is out of their competence. Subsequently, page 51, the state has also requested you.
First or second or third.
Why the BTC is saying it is out of your competence? Under what provision?
Because it will become a gazetted post and we don't have, because.
You don't have is on the basis of what? Some rule, regulation, gazette notification? What?
Because Lordship, we had followed regarding the agreement which has been cited.
So where does it?
Clause H of that,
Hmm.
memorandum, Lordship, whereby it stated that, with the.
It's number 4.
59. Clause H, Lordship, which your Lordship had drafted with this line. At the last line.
Page number,
60, Lordship, because see.
60.
60, Lordship. However, the post where recruitment is to be made in the recommendation of APSC shall not be covered under this provision. That is all the appointments and with regard to promotion also. Clause H means Lordship, BTC.
So under what provision is the recommendation required? What rules?
Lordship, some tourism rules will follow, Lordship.
Where is that?
Some tourism rules, Lordship, in the repetition.
Yeah.
Is in Annexure 12, Lordship.
Page number?
Annexure 12, page number. Hmm, 56, Lordship, page number 56, Lordship. Page 46, Lordship, please starts, Lordship. In the PPC, Lordship, 5568, Lordship. Page 46, Lordship.
46.
Yes, Your Lordship.
In which writ petition?
WPC 5568, Lordship.
5568.
Lordship.
5568. WPC 5568. Page 60.
52, Lordship.
52.
Clause 14, clause 2, Roman number 3A, Lordship. Last clause, Lordship. A member shall be considered for promotion to the cadre of tourist information officer under sub-rule 1 of this rule. If A is rendered services in the cadre of ATIO for a minimum period of 5 years and on the first date of January of the year of promotion, provided the governor in appropriate cases may relax the period of service herein before prescribed. B, he has passed such departmental examination or equivalent examination has been prescribed by the government. And C, he has successfully undergone such training as been prescribed by the government for the purpose. And Lordship 14.1, subject to suitability has been decided by the committee and by the appointing authority in accordance with the procedures set forth in Rule 50. And also subject to possessing the experience as prescribed under sub-rule 2 of this rule, a member shall be eligible for promotion to the corresponding higher cadre in the manner provided herein below. 1 from ATIO, 2 Tourist Information Officer, 2 from Tourist Information Officer or Deputy Director, 3 from Deputy Director to Joint Director, 4 from Joint Director to Additional Director. So Lordship, this is the reason we are unable to, Lordship.
I think you are referring to page 54, para 6. Clause 6.
No, Lordship, page 52, Lordship.
52.
52, Lordship.
52.
Where it talks about clause 14, Lordship, 14(1). Subject to suitability as will be decided by the committee and by the appointing authority in accordance with the procedure set forth in Rule 15 and also subject to possessing the experiences prescribed in the sub-rule 2 of this rule. A member shall be eligible for promotion to the corresponding higher cadre in the manner provided herein below. The Lordship, from ATIO to Tourist Information Officers, that falls under the rules prescribed by the Assam Tourism. Lordship. So finally.
No,
just the-
your embargo is in respect of matters where commission's view is required.
Lordship.
So where is it provided? It is at page 54, clause 6.
Lordship, Commission shall consider a list prepared by the committee in respect of promotion to the cadre of additional director, joint director, deputy director, and tourist information officer, along with character roles and personal files of the employees, and approve the list unless it considers any change necessary. If the commission considers it necessary to make any change in the list received from the committee, it may approve the list finally with such modification, if any, as may, in its opinion, be just and proper. The list, as finally approved by the commission, shall form the select list for the purpose of rules 14 and sub-rule 9 of this rule.
Where is that BTC agreement again? Memorandum?
59, Lordship, 59 clause H.
59.
Clause H. Lordship. BTC shall be competent to make appointment on all posts under. WPC 659, Lordship. Clause H, Lordship. BTC shall be competent to make appointment on all posts under its control in accordance with the rules of appointment followed prescribed by the Government of Assam. The council shall constitute a selection board for appointment to be made by it and shall also make use with the approval of Government of Assam to regulate appointments. All circular relating to the filling of vacancies and appointments issued by Government of Assam from time to time shall be followed fully. Lordship, thereafter page 60, Lordship. However, the post where recruitment is to be made on the recommendation of APSC shall not be covered under this provision.
Creation to continue. Creation not accept.
You are not allowing the BTC to make promotions by virtue of this clause.
I believe in the BTC also, there is one post of sanctioned post of.
All right, but your agreement says that this recruitment will not be applicable where the recommendation of APSC is required. It is excluded. So the main parent rules for the promotion to the post of tourism information, the commission has to approve the list recommendation, which the BTC can't do.
Yes.
You have stopped them from doing it.
I have not, the rule is there,
So whatever you made a rule.
Yes.
And then you say that they are ex-cadre, so therefore they are not to be included in the part of this cadre. How is this possible?
My lord, the rule is there for the entire state. So far as BTC is concerned, there is a sanctioned post of
correct, but this BTC, you are giving the BTC the power on the basis of the office memorandum. You don't deny this office memorandum. This office memorandum contains a clause where it says appoint, except those posts where recommendation is required.
No, otherwise also, my lord, in the rules which is applicable for the officers in the state cadre, my lord, there is a requirement of the approval by the commission.
That's right.
Now,
therefore, what you intended to do, give the BTC that no, we give you the powers.
Yes.
Make appointments, except those posts where recommendation is required. So this is the post under the parent rules where recommendation is required.
Yes.
It has been sent to you. Now you're tossing it across.
No, man. There is one vacant post of sanctioned post of tourist information officer to which
We
my land
understand that, but that requires recommendation of the APSC.
possibly not, my lord. So far as BTC is concerned, in that post, I am not very sure they will be able to tell
No,
us.
it is here, page number 58 of the writ petition. Or rather, 58 is the agreement and 60 is the relevant part.
Of full petition.
60.
It's sidelines.
Next part.
However, the post where figure it means to be applied in the recommendation of this issue. 400 is provision. Now, so for all the ports which are given to the BTC, the question of interference by the commission will not come. So
We don't know, that's what the agreement says,
my lord.
unless you clarify
Yes.
that this
No.
has to be. According to me, this clause appears to be out of place.
But the,
Because otherwise, what is the point in giving them 6th schedule?
oh, yeah.
But then it is a part of the MOU, which is not under challenge.
Yes, that is one. And MOU has been prepared manner in a completely different manner. So here possibly
They
they
get that clarification that BTC is not required to send it to APSC and they are competent to appoint. We'll pass orders.
well, a question possibly subject to correction. What I'm trying to convey to your lordship is that there is certain sanction post for the BTC. For the BTC is the final authority to make appointment to all those posts. There is one post to which my learned friend's client is trying to get promoted. That post is available to them. So far as that post is concerned, they will make the appointment in accordance with their own procedure. The tourist information officer post in the state cadre, for that only this commission's recommendation and approval, etc. is necessary. What the writ petitioner is trying to do is, since that post is not vacant, she is trying to get appointment to the state cadre.
No, that post is vacant.
That post is vacant.
Vacant.
That post is vacant. They have given that it is vacant. You give the approval, we'll promote. That is what the letter says.
That question did cross our mind
But that's
quite
what
some
I mean,
time back.
that's what I tried
But
to-
he clarified, saying
Ah.
that no, that post is vacant. So therefore, come to page number 59, clause number H.
H, yes.
H.
BTC shall be competent to make appointment on all posts under its control in accordance with the rules of appointment followed prescribed by the government of Assam.
We pause here for a moment.
My lord.
So BTC is to make appointments in terms of rules followed by the government of Assam. So therefore, tourism posts to be filled up by the rules of tourism which are framed by the government of Assam. So you make unilateral appointments, except in page number 60.
Yes. However, the post where the recruitment is to be made on the recommendation of the APSC shall not be covered under this provision.
So therefore, again,
My lord.
if you come to the rules,
Yes.
where are the rules?
You'll find
5568.
No, it's here in this
5568.
petition also. In the subsequent petition also it is there. Somewhere. 659, is it there, Mr. Manan?
Yes, it is at page 65.
65. 65 are amendment rules, I think.
No, this is the
Amendment is
original
165.
1995 original.
Amendment also we have
Alright.
produced.
So now here if you come to page number
72.
72, rather 73.
It will be 73.
73.
6.
This is the procedure to be followed. In the procedure, commission shall consider the list. And the posts to which the names are to be considered are mentioned, which includes tourism information officer.
Yes.
So therefore, tourism information officer promotion list will have to be sent to commission. Yes. But they can't send it because you've excluded it from the MOU. You are not sending it because you say, no, these are ex-cadre posts. So therefore, there is no question of ex-cadre. Since you have restricted the BTC to not to send, not to appoint, BTC has not appointed, saying that these are names to be sent to APSC. So now, therefore, you will have to get the names approved through APSC and give the green signal to the BTC to appoint. Which gives rise to a further query later that assuming the posts end up in the cadre of additional director. Yes. One additional director in BTC, one in state of Assam. Now the post of director has fallen vacant.
No appointment.
So the director, additional director in BTC will again be told you are ex-cadre.
This is what the party.
We are ready to dictate the order if you are ready to listen to it.
So far as that post of tourist information officer in the BTC is concerned, what is the present status, my lord?
No, it is
No, he
vacant.
says it is vacant.
They have stated it is vacant.
I know Mr. Mandane says it is vacant.
No, in fact, they have also, BTC also said. it is
BTC also says it is vacant. So even if this is vacant,
My lord.
even if the name of the petitioner is to be recommended for promotion to the post of tourist information officer in BTC, that under the rules require the list to be to be sanctioned or ratified by the APSC. So therefore, they cannot promote. BTC.
Yes.
They have washed their hands off, saying that we will not promote. They have not even attempted to send the list to state government to say that please get it ratified.
My lord will kindly take up the affidavit filed by us, my lord. There, my lord, we have taken the stand why it is not possible.
Affidavit filed by which respondent?
It's
Three,
phone
it's
number
three.
3, man.
Respondent.
Page 151.
151 onwards.
(151).
There are other difficulties also, my lord.
Yes.
Page, Lordship may kindly turn to paragraph 4 at page 152. That with regard to the statements made in paragraph 2 of the petition, the answering deponent begs to state that as per the BTC Secretariat Kokrajhar notification number so and so dated 30th of July 2007, the powers and functions of the Central Selection Board are mentioned in clause 4 of the aforesaid notification as follows. The Selection Board shall abide by the BTC service rules in respect of the recruitment of personnel for BTC Secretariat, and such are the rules now in force in respect of the recruitment of personnel for 40 transferred subjects. The answering deponent further states that as per the Schedule 11, Rule 210 of Assam Tourism Service Rules 1992, the minimum qualification and experience prescribed for direct recruitment for the post of Assistant Tourist Information Officer is as follows. A degree in Arts, Science and Commerce of a university recognized by the government. The candidate should be capable of expressing himself in English properly and fluently, as he will have to deal with foreigners and tourists from other states of India. Whereas the required qualification for the post of Assistant Tourist Information Officer BTC mentioned in the advertisement published on so and so was the minimum education qualifications graduate in Arts, Science and Commerce, diploma in tourism and hotel management, etc., proficiency of language in English, Hindi and Assamese Bodo. Then next page, my lord. As such, the qualifications, the requisite qualification for the post of ATIO BTC is not at all similar to the requisite qualification for the post of ATIO under the Assam Tourist Service Rules 1992. This is number 1, my lord. Secondly, further, the appointing authority in respect of the petitioner is also not in accordance with Rule 2A2 of the Assam Tourism Service Rules 1992. Whereas the appointing authority in respect of the cadre Assistant Tourism Information Officer is the Director of Tourism and not the Director cum Council Head of Department Tourism, Department BTC, which is in the rank of Additional Director. Hence, the petitioner cannot be considered as one of the incumbents in the cadre of ATIO under the Directorate of Tourism, Government of Assam.
It doesn't throw any light. See, it is a sixth schedule.
Madam.
Council.
Yes.
So how can you restrict their powers is number one. Number two, notwithstanding that you have restricted their powers, the MOU is still in force. According to the MOU, they cannot send it. They cannot appoint.
They cannot appoint.
They may be able to send it, but perhaps it has to be routed through the
commission,
office of the principal secretary or something like that.
Yeah.
So therefore, unless the MOU is very clear that the appointment shall be made in terms of the service rules followed by the state. So therefore, it will not be an ex-cadre post.
No, this is in respect of other posts. But when it is specifically stated in respect of some post is necessary, then that has to be followed. This is in respect of other posts where the procedure is not coming in the way. Here, there is a requirement of approval from the commission.
No, that's right. The requirement from approval of commission is for the state to get an
But
approval.
the provision in the rules which says that they will fill up the post in accordance with the rules of the state is because in respect of appointment for other posts also, there is no specific rule for in the BTC. So they will follow the state government rules.
State, right. Even for tourism, there is no separate rules.
That is why.
So they'll have to follow the state rules.
Yes. Now, following rules is
The
one thing.
whole purpose is that once you have a separate rule, you have a separate cadre. So had the BTC, had it been conceived that there will be separate cadre for BTC and for Assam,
this is
separate
what the
rules have been followed, have been followed.
This is what the affidavit says, that cadre itself is different. This is what they are trying to say.
On what basis
And-
they are making this statement, we don't know, because
And-
cadre to be different
Madam.
will require creation of a cadre.
No, cadre for the BTC cadre separately created.
No. Separately created, where is the creation order?
That is there, madam.
Creation, you will also find it page.
You should find it in the
Page 35.
page 35 of the read petition.
These have been regularized now,
It says temporary post.
still temporary.
She has ultimately, there's an order for. That is page 42. Permanent retention order has and sanction has been accorded. The five post permanent retention created under non-plan head in Director of Tourism Board and Tourism Council. This is an order issued by the Tourism Department at page 42.
So it has been
Permanently, and it's a non-plan. Now it has a non-plan post and everything. It has been permanently.
But in the
Then
past,
her service was confirmed at page 43.
at page 42, Lordship will find that while permanent sanction was accorded, it is only in respect of one post of Assistant Tourism Tourist Information Officer. That post of Tourist Information Officer is not there. I think that is the problem there.
Yes, BTC. Give us a clarity whether these posts at page 35 have all been retained permanently at 42.
42 shows ATIO senior assistant, but it is not showing with regard to.
So what has happened? Is it retained? Is it there? Is it not there? Some separate retention order is there?
Also, will kindly take up page 39. Here they have stated inviting reference, I have the honor to inform the government has created number of posts. Department of Science headquarter in the sense all sanctioned posts have been filled up by observing formalities except the post of tourism information officer and lying vacant, which is to be filled up by the APSC asked.
That was the position in 2012.
Yes.
But subsequent permanent retention came in 2015.
That came, but this post did not come.
That is what.
That was, I think, vacant.
No, there is no post. No sanction, permanent sanction is not, it's not there.
42 does not disclose.
BTC will have to clarify, give us a clarity of what is this?
Get some instruction.
Not some instruction, we want
Clear,
specific instruction.
clear stand has.
On that. That
And
post has been.
why not the BTC give a promotion and take approval from the APS?
Provided the post is still there.
And that is, that they will have to clarify, but that also could have been done.
Could have been done. But
Just
that is-
writing for putting the name of the petitioner in the gradation list, they could have said that also. That is one option. I'm just making my observation. Because this case also, I found it to be very difficult to understand why it has been running like that.
Let them clarify what is the position with regard to the.
Day after tomorrow? Get a clarification. Heard Mr. Y.S. Mannan, counsel for the petitioner, Mr. D. Majumdar, additional Advocate General, Senior Advocate, Additional Advocate General, Government of Assam. Mr. Your name?
MK Das.
MK Das, appearing for the PTC. Mr. G.I. Borgmia for
private respondent.
Respondent, MSP Sharma for APSC. The list before this court is the claim of the petitioner who is presently serving in tourism, assistant tourist.
Now it is tourism development officer. Earlier it was information.
Assistant tourism information officer, now re-nomenclatured as
Assistant tourism development officer.
assistant tourism development officer.
Tourist development.
Tourist development
Tourist
officer under the BTC. Stop. Petitioner claims to be eligible for promotion to the next higher post of tourism information officer.
Tourist development officer.
Next promotion, tourist
Development officer, not assistant, now tourist development.
earlier she was assistant tourism.
Tourist information is
Information officer.
redesignated as tourist, assistant tourist
Okay,
development
okay.
officer.
Assistant tourist development officer. I got a assistant tourist information, then re-nomenclatured as assistant tourist development officer, claiming promotion to the post of tourism development officer.
Yes.
So. The petitioner claims that she has all the adequate eligibility, attained the eligibility. However, the BTC authorities have not considered a claim for promotion and have held that in terms of the MOU executed between the state of Assam and the BTC authorities, all posts, all appointments under the BTC, all appointments to various posts where in respect of the transfer departments were to be undertaken by the BTC except those where the recommendation is required from the APSC. Stop. Learned Counsel for the petitioner submits that in terms of the tourism service, the service rules governing the tourism department, for promotion to the post of tourism information officer, now renomenclatured as tourism development officer, the sanction or recommendation of the APSC is required. So, the BTC authorities therefore communicated with the state counterpart and also informed the petitioner that since recommendation of APSC is required, her claim for promotion to the next higher post cannot be considered. Stop. The state has filed its counter affidavit to submit to state that the petitioner is not eligible to be considered for claims in the state tourism department as the post of tourism assistant tourism information officer, alias assistant tourism development officer, and tourism development officer are ex-cadre posts. Stop. It is their contention that since these posts were separately created for BTC by specific orders, their names cannot be, her name cannot be included in the gradation list maintained by the state government. Stop. That apart, qualifications and eligibility criteria are different. Stop. Better. Considering the submissions made before the court and upon consideration of the pleadings available before the court, it appears to the court that the BTC being a sixth scheduled council is empowered to make appointments to all its posts in respect of the transfer department. Stop. Tourism is one such transfer department. Stop. However, as per the MOU executed by and between the state, there is a specific provision that all appointments in respect of the transfer departments will be made by the BTC, subject to those posts where recommendation of APSC is required. Recommendation or sanction of APSC is to be required. Stop. Under the service rules governing the services of the tourism department, there is a clear provision that for promotion to the posts of tourism development officer, earlier known as tourism information officer, the recommendation of the APSCs, that the sanction of the APSCs required. Stop. At the same time, the posts which were originally created for BTC, including the posts of assistant tourism officer and tourism assistant tourism information officer and tourism information officer, subsequently came to be permanently retained by a separate order, a copy of which is available in the pleadings. Stop. However, the post of tourism information officer is not shown to be the post, one of the posts in the order by which several other posts, including the post of assistant tourism officer, came to be permanently retained. Stop. Better. The question therefore rises before the court is whether the post of tourism information officer, now renomenclatured as tourism development officer, is still available under the BTC, and if so, what is the status, and are there any vacancies available? Stop. These instructions are not available with the learned BTC council, standing council for BTC. The learned standing counsel for BTC will therefore endeavor to obtain these instructions and place it before you for further consideration of the matter. List again on. Lordship, can it be on Monday, Lordship? Tuesday, 29th. I'm sorry, 9th. 9th of December. List on 9th of December. Both matters.
Obliged.
Yes, 9th of December. For further hearing. কারণ থেকে আসে নাকি? হ্যাঁ? দিয়ে দিও, মাটি দিও। দিয়ে দিও। You may take leave. We'll have to dictate a order.
So dictation again, question 1. Yeah.
Both parties are available. You are for the petitioner.
Mine. I am for the respondent number 4.
I heard learned counsel for the parties. This petition is filed by the petitioner. Assailing the promotion. This is promotion, appointment of the private respondent to the post of administrative officer under the Assam District Services Government Council and Standing Council GAD for this, I think, 8 and 9. Assam Ministerial District Establishment Service Rules 1967. So. Both the petitioner and the private respondent are serving as what? Senior assistants.
I was senior assistant.
Both. Petitioner also.
Petitioner different.
Senior assistants in the district of Bojali. Bojali. So, pursuant to an advertisement issued by the office of the Deputy Commissioner for filling up of the post of administrative officer in the amalgamated establishment of Deputy Commissioner Bojali by advertisement dated 17/7/2021. Both the petitioner and the private respondent, along with other similarly situated persons, submitted their candidatures. Their candidatures were duly considered and pursuant thereto, the selection board recommended the appointment of the private respondent for the post of administrative officer. So in pursuance thereto, the competent authority in the government issued the appointment order dated 2/3/2024. Stop. Parent. Writ petition, which was filed earlier?
133,
Huh?
1338 oblique 2024.
1338 of 2024 was filed by the petitioner challenging the recommendations.
Yes.
Challenging the recommendations of the
Respondent
selection body. Subsequently, when the appointment order came to be issued, WPC 6583 of 2024 was filed. Stop. Both the writ petitions, therefore, are taken up and for hearing and disposal. Stop. Para Mr. P.K. Roy Chaudhary, learned counsel representing the writ petitioner, has assailed the recommendations and the consequential appointment to private respondent on the ground that the private respondent does not fulfill the eligibility criteria specified under Rule 8(1) within bracket small a of the Assam Ministerial District Establishment Service Rules 1967 within bracket hereinafter referred to as the rules of 1967. Stop. It is the contention on behalf of the petitioner that the petitioner satisfies the criteria specified under the rules, but the private respondent does not. However, this was overlooked by the selection body and also by the appointing authority. And therefore, the selection and appointment of the private respondent is contrary to the provisions, contrary to the criteria specified, is in conflict with the criteria specified under Rule 8(1)(a) of the rules of 1967. Stop. The learned counsel for the petitioner strenuously submits that the Rule 8(1)(a) specifies experience of 15 years in any deputy commissioner's establishment and experience of having worked in different branches in general, and also the establishment branch in particular. Stop. Referring to the particulars available in the pleadings, learned counsel for the petitioner submits that the petitioner had more than 15 years of service and has the experience of working under different branches, including the establishment branch under the office of the deputy commissioner. Stop. However, the private respondent, although has some experience of rendering services in different branches, however, he does not have the experience of rendering service in the establishment branch in particular. Stop. It is submitted that the minutes of the meeting which are enclosed to the writ petition does not take into consideration this fact. Stop. Insofar as the writ petitioner is concerned, it is reflected that the petitioner has worked under the personnel within bracket establishment branch with effect from 27/3/1987 to 31/7/1989, which is for 2 years and 4 months. Stop. Whereas, in so far as the private respondent is concerned, he had rendered services under the personal branch and administration branch. Stop. Referring to the particulars reflected in respect of the private respondents in the minutes, learned counsel for the petitioner strenuously urges that the personal branch works undertaken by the petitioner, by the private respondent, is shown to have been in respect of matters relating to accounts and establishment. Stop. According to the learned counsel for the petitioner, this will not satisfy the criteria specified under Rule 8(1)(a) that the candidate must have rendered 15 years of service in various branches in general and in the establishment branch in particular. Stop. It is urged before this court that experience in personal branch and administration branch cannot satisfy the criteria specified under 8(1)(a) of having experience in the establishment branch. Stop. A learned counsel for the petitioner therefore submits that where the private respondent does not satisfy the criteria specified under 8(1)(a), it was incumbent on the selection committee as a body to consider him ineligible and instead recommend the writ petitioner for the post of administrative officer. Stop. The learned counsel also submits that the appointing authority has also failed to take into account the shortcomings in the selection committee and ought not to have been bound by the recommendations recommending the name of the private respondent when the private respondent does not satisfy the criteria specified under Rule 8(1)(a) of the rules of 1967. Under such circumstances, the writ petition be allowed, the impugned order of the impugned selection minutes be interfered with, and the impugned order of appointment be also interfered with and set aside. And the matters ought to be remanded back for a fresh decision on the matter, and thereafter fresh appointment orders are called for. The case of the petitioner has been contested by the state respondents as well as by the private respondents. Stop. The state respondents represented by the government advocate as well as by the standing counsel GAD submits that the due process prescribed under this under the rules have been scrupulously followed, and there is no infirmity in the selection process, and consequently no interference is called for as prayed for by the writ petition. Stop. counsel for the private respondent, Mr. Islam, also strenuously urges before the court that the private respondent, has satisfied all the norms and therefore does not require and therefore fulfills the criteria specified under Rule 8(1)A of the rules and therefore does not require interference. So the case projected by the writ petitioner is incorrect and the private respondent has sufficient experience to his credit and fulfills all the criteria specified under the provisions of the rules. Stop. You relied on some judgments, huh? Petitioner? Some judgments were relied on.
Yes, yes.
The learned counsel for the petitioner submits that
Well, that doesn't Bhuvneshwar Sharma.
Bhubaneswar Sharma, like 24/5 GLT.
Yes, has relied on the judgment of Bhubaneswar Sharma. It was very asset. That the appeal judgment was, it has been appealed. The judgment was tried over third school. Huh? Relying on the judgment, the learned counsel for the petitioner submits that this particular judgment has held that the criteria specified under the rules that the number of years of service required to be rendered under Rule 8(1)A is a valid criteria and must be followed. Stop. He therefore submits that where this court had already had the occasion to examine the criteria specified under the rules of 19 something, ministerial rules of 1967, it was incumbent on the respondent authority to examine the qualifications in terms of the procedure prescribed under the rules of 8(1)A of the 67 rules. So the learned senior counsel has further referred to a judgment of the apex court rendered in Ritu Bhatia. reported in 2019 3 SCC 422. Agortu is it 2024 5 GLT 75. Bhubaneswar Sabha. Learned counsel for the petitioner pressing the judgments into service has held that where the period prescribed under the rules is specific, then the authority cannot dilute the eligibility criteria prescribed under the rules. So it is therefore submitted that where the rules 81A specifically provides experience in the establishment branch, comma, the private respondent not having the requisite experience of serving under the establishment branch under the Deputy Commissioner's office, comma, cannot be considered to be eligible, notwithstanding the private respondent has fulfilled the criteria of 15 years of service working in various departments, various branches. So he therefore submits that the impugned order dated so is interfered with, set aside and quashed. Para. Par contra, Mr. Islam has placed reliance also on the judgment of Bhubaneswar Sharma Supra rendered by this court to submit that the court has held that where the departmental authority has followed the rules and has conducted the selection process, the writ court will not exercise judicial review to examine the relative merits of the candidates. Stop. He has further referred to and relied on the other judgments rendered here. The records available before this, records of the selection process has also been placed before the court. Learned counsel for the parties have been heard, pleadings available on record have been carefully perused. Judgments cited have been carefully noted. And at the outset, it is necessary to refer to the relevant rules. Rule 81A of the rules. Rule 8 prescribes the rule as under. Relevant portion of the rules are extracted below, namely Rule 8.1 and Roman 3. Extract. The although the rules prescribe that the eligibility should be 15 years of experience in any deputy commissioner's establishment and experience of having worked under different branches in general and the establishment branch in particular, comma. During the course of the hearing, the counsel of the bar appearing for the parties have accepted and agreed that presently under the Deputy Commissioner's establishment, there is no specific establishment branch. So the branches which are available are described in a notification which is which has been notified by notification number so and so, dated 11th May 2018, page 104. But chapter 1, the tick mark, the various branches under the Deputy Commissioner's establishments are as under 1 to 27. Insofar as the personal branch is concerned, they are required to undertake the following works. Page number 107, serial number 12, personal branch, ABC. A perusal of these branches reflected above reveal that under the personal branch, it consists of two sections, namely the personal section and the account section. Under the personal section, the establishment matters of officers and staff are included. Stop. Therefore, the prescription under the rules that specific services in under various branches and establishment branch in particular will have to be understood in terms of the branches which are presently available under the district establishment. Stop. From the notification extracted above, it is clear that there is no separate establishment branch in the district district establishment. Stop. However, there is an administrative section which is there is an establishment section under the personal branch. Stop. The minutes which are reflected in the which are enclosed to the pleadings, as also is evident from the records placed, reveal that where are the minutes?
Yes, 22
minutes reveal that the ACR gradings as well as the experience in respect of relevant.
Page 82 of our affidavit annexure 4,
relevant branch is reflected. Is there any dispute with page 24?
No. Oh, in the writ petition. Same document.
Then we are relying on that. Insofar as the writ petitioner is concerned, the following particulars are reflected in the selection process. During the selection process, page 24, serial number 1, extract. Insofar as the writ petition, private respondent is concerned, the following particulars are reflected. Page 26. Stop. Finally, the selection committee, upon reviewing the track record of the applicants and after threadbare discussion, after due deliberation and discussion, recommended as under. Page 27, tick mark to tick mark. In terms of this recommendation forwarded, the writ petitioners, the Department of General Administration issued the appointment order dated 2/3/2024. Stop. Yeah. Upon examination of the particulars which are reflected in the reports, it is seen that both the candidates have sufficient experience of working in various departments. The petitioner appears to have rendered more service in the personnel establishment branch, whereas the private respondent number 4 also is shown to have rendered service in personal branch relating to works relating to accounts and establishment, as also in the administration branch. So the gradings reflected in the ACRs for the years under consideration are also noted. Stop. The state has also filed their affidavit to substantiate its contentions that the works which are carried out by the private respondent in the personnel department are required to be executed in closed quarters, are required to work closely in both accounts and establishment sections. Stop. Yeah. The main the primary challenge in the writ petition, the only challenge in the writ petition is that the petitioner, the private respondent, does not fulfill the criteria specified under 8(1)(a) of having rendered services under the establishment branch in particular. Stop. This during the arguments and the pleadings available before the court, it is clear that under the Deputy Commissioner's establishment, there is no establishment branch within courts in particular. Stop. However, the personnel branch has establishment section amongst other sections in which the incumbents are required to render their services and gain necessary experience. Stop. Therefore, where the establishment concerned does not does not have the establishment branch as specified under the rules, the services rendered by the incumbents and the experience gained by rendering their services in various sections, including that of the various branches, including that of the personal branch, under which within quotes establishment section is also one of the sections, the strict application of the criteria under 8(1)(a) cannot be applied in the present, under the present circumstances. Stop. The fact that the candidates have rendered experience, have rendered their services and have gained experiences on the various sections, on the various branches, and which also includes the establishment section, will have to be considered to be substantial compliance of the criteria specified under Rule 8(1)(a). Stop. This strict interpretation that the the compliance of the eligibility criteria under Rule 8(1)(a) will have to be understood in terms of the branches which are now available or maintained under the Deputy Commissioner establishment. Stop. That apart, by the advertisement dated 17 July 2021, which invited applications for the administrative officer from amalgamated establishment of Deputy Commissioner Bojali, the criteria prescribed was 15 years in any of the Deputy Commissioner's establishment and should fulfill eligibility conditions and have experience as per the Assam Ministerial District Establishment Service within bracket Amendment Rules 2009. So the rules which are quoted above are the rules which were brought in the rule book pursuant to the amendment in 2009. Stop. The petitioners also do not dispute the position on facts that presently under the district establishments, the Deputy Commissioner's establishment, there is no specific establishment branch within quotes available. So, under such circumstances, it must be held that both the candidates have fulfilled the eligibility criteria specified under the rules to a substantial extent, which has been considered to be sufficient by the competent authorities. Stop. The law governing the judicial review under Article 226 of selection procedures is well anointed by the apex court as well as by this court. Stop. The judgment of Bhubneshwar Sarma rendered by this court was in respect of the selection made to the same post of administrative officer. Was it administrative?
That was the post of Seristada.
Sorry, it was the post of Revenue Sirastada on the basis of assessments made on the ACRs. Stop. The court upheld the same selection and also held that selections made on the basis of ACRs, unless the same are assailed on the ground of violation of any specific rule or on the ground of malice, the choices made by the competent authority ought not to be interfered with. Stop. This judgment subsequently came to be upheld by the division bench in writ appeal numbers 211 of 2024, order dated 13/11/2024. So, in Ritu Bhatia, Supra. The question before the court was the eligibility specified under the rules, which the litigant before the courts did not specifically fulfill. And the experience rendered as a management trainee was sought to be interpreted to be sufficient experience required under the rules therein. Stop. The there is no quarrel with the proposition that the qualification specified under the rules are required to be scrupulously followed, and selection of the candidates must be made by strictly adhering to the criteria specified under the rules. Stop. However, in the facts of the present case, as have been discussed, the criteria specified was 15 years of experience in various branches under the Deputy Commissioner's establishment, with emphasis on experience in the establishment branch in particular. Stop. However, presently under the Deputy Commissioner's establishment, in respect of the advertisement under consideration and the selection, advertisement and selection under consideration, admittedly, there is no establishment branch. Stop. In the office memorandum dated so and so, where the branches are specified under the establishment, Deputy Commissioner's establishment, the establishment branch within quotes is not specified therein. So, under such circumstances, the criteria adopted by the selection committee of accepting the services rendered by the incumbents, including the private respondent, in various branches, and as well as the services rendered under the establishment section, have been taken into consideration and considered to be satisfactory, considered to be compliance with the rules. Stop. Therefore, the proposition, the judgment in Ritu Bhatia on the facts of the present case does not come to the aid of the writ petition. Stop. In the celebrated judgment of the apex court rendered in Dalpat Abasahib Solanki, reported in so and so, the apex court clearly held that there has to be greater restraint in matters or where selection committee where in matters relating to deciding the relative merits of candidates in the process of selection undertaken by the selection committee. Stop. The apex court held that a court has no expertise in respect of matters which are within the domain of constituted selection committee, and therefore ought not to embark on the aspect of deciding the relative merits of the candidates per se. Stop. এটা Jasmine Didi বলেই in so and so versus so and so. Stop. Correct. In view of the law enunciated above, it is clear that the parameters of judicial review in respect of selections being made are ordinarily within a narrow campus, as the same ought not to be generally interfered with unless there are glaring irregularities and obligor malice is attributed to the candidate or to any member of the selection committee or even to the appointing authority. Stop. From the pleadings urged before this court, it is clear that there is no malice alleged against the private respondent or the selection body or the appointing authority. Stop. Malice in law, although need not be specifically urged, is also not made out in the facts of the case, as the rules, the rigors of the rules have been followed to the extent the same are applicable in the present setup in which the offices, the establishments of the deputy commissioners are currently being managed and are currently run or currently operated. Stop. Under such circumstances, this court does not find any grounds to interfere with the selection and the appointment order of the private respondent number so and so. The writ petition is devoid of any merit, therefore fails, and the same is therefore dismissed. No order is to cost. Interim order. Was there any interim order?
No, my lord, no.
All right. I got at the line bigger. The records which have been placed before the court have been duly examined. And no grounds to interfere have been noticed upon careful examination of the records. So the relevant records which have been placed before the court are returned to the standing council GAD.
No, my lord, to the government advocate, A. Chakraborty.
Are returned back to the government advocate, Mr. A. Chakraborty, in court. Courtmaster will hand over the records to the learned government advocate.
I'm appearing for the GAD.
Huh?
I'm appearing for the GAD.
We have recorded you.
Fine.
You have not produced any record.
My lord, last time we had produced it, but then this time your lordship had asked them to produce.
Huh?
Your lordship had asked them to produce
All
the
right.
main record. So we had already got
Okay.
the record.
Disposed.
Fine.
My lord, just one line. I am for respondent number 4, R. Islam, assisted by S.K. Das.
R. Islam assisted by Mr. S.K. Das.
Das.
And P.K. Roy Chaudhary assisted by
A.K. Azad.
A.K.
A.K. Azad.
Azad.
Fine. All right, sir.